Lordship. Unusual pair for the prosecution side, Lordship. In respect to the all pending cases, we are facing difficulties, Lordship. Top of the list matters, almost all the matters are, Lordship, way back to 13, Lordship. Then, Lordship, we have not a single piece of paper, Lordship.
Take up the second files.
Otherwise,
Can't help it.
Second file also, Lordship, we have to go to the evidence, other things. So, Lordship, at least some time may be given to us, Lordship.
These matters we are not adjourning, Mr.
I am not seeking adjournment, Lordship.
You go ahead, watch it, see it. By the time we'll hear the...
Otherwise, Lordship, for proper assistance, it will be difficult.
I understand. I require your assistance. We'll try how we can work out case by case. If some difficulty is faced, we'll face it at 2 o'clock. No problem. Okay.
Please, your Lordship. Lordship, item number 72, Lordship. Another date, Lordship, and for hearing, Lordship, and top of list, Lordship. 2020's case, Lordship, and he's in custody more than half punishment, Lordship.
We'll take it up. What is there? It's in orders. Why is it come in orders?
IA's, Lordship, there.
IA. IA for?
For bail.
20 matter, we'll hear it. Why bail now? What is the punishment?
10 years, Lordship. And already more than 6 years in jail, Lordship.
Mr.
F.
Learned Counsel for the petitioner prays that there is urgency in the matter and accordingly seeks an out of turn hearing. Accordingly, a registry to list this matter on 17th in the top of the list.
Deeply obliged, Lordship. Obliged.
May I please? I beg to mention here item number 64 of today's list, Lordship. Here, Lordship, in cross case, Lordship, that criminal appeal number 351/24 is already admitted and that is listed before the division bench. So may I pray this present matter will be tagged along with that case, Lordship.
Duta Bazar Law, 2 p.m. 2 p.m.
So, Lordship, I'm saying that already in that.
I'll just go through it. I've not gone through it. I'll go through it and I'll pass it.
Hey, please, your Lordship. Lordship, with the consent of the other side, I beg to mention item number 62, Lordship. That status of the proceeding in the trial court was sought for, Lordship. But the respondent number 5 is unwell, Lordship. He is admitted at AMC, Lordship.
Who?
Some accommodation may be granted, Lordship.
Who?
That Junu Das, Lordship.
Oh, that it is with regard to
Section 76 and Section 64, Lordship. Of 2013 Act, Lordship. Some time may be granted, Lordship.
have you taken the consent?
Lordship, I have 40 PDF now.
No objection. Why is it before me? I had kept it for further hearings. Some filed to 60, 62 too. Yes, next.
Please, also, I beg to mention item number 75, hearing matters, Lordship. We have mentioned accordingly the matter is listed today. In this case, some urgency is there, Lordship. This matter may be taken up on 23rd. Today's possibility very less, so Lordship, it will take on 23rd in the top of the list, Lordship, hearing.
Not in the top of the list. 25 matter. It will come. We'll fix a date for that. 75 to not go it over. Mr.
P. Bodle, Lordship.
P. Bodle, Learned Counsel for the petitioner, for the respondent number 4.
As Lordship, 5 probably.
Respondent number 4 submits that he be granted further 2 weeks' time to complete his instructions in terms of the query raised by this court vide the order dated 28/8/2025. So, prayer is not objected to by the Learned Counsel for the petitioner. So, accordingly, a registry to list this matter again after 2 weeks on a date to be fixed by it. So, this matter shall not be considered as a tied up matter with this court any further.
There is a prayer, Lordship, with regard to item number 39, Lordship. Appearing on behalf of Mr.
Rejected.
The Lordship.
Rejected. It is with regard to that opium. Prepare the case well.
Supplementary list.
Mr. Chaudhary, we had kept these matters
Yes,
today
yes,
because Madam has said that the,
Petitioners have expired.
Expired.
Both the petitioner.
so it is rendered,
Yes.
it will stand abated. Shall we close the matters?
Yes, my lord. This is with-
Heard Mr. B.M. Chaudhary, learned counsel for the petitioner, and Miss Madam
Manorma Kumari, M.
M.
Kumari.
Kumari, learned standing counsel, CBI, appearing for the respondents. First off, the respondent authorities, respondent CBI has filed an affidavit in the matter and therein have highlighted that the petitioners in the above noted criminal petitions. Duta ekalage mariba.
One case,
Have-
my lord, C appears. Mr. Katoki, my lord, Begum.
Heard Mr. B.M. Chaudhary and Miss
R. Begum.
R. Begum, learned, Mr. B.M. Chaudhary, learned counsel for the petitioner in WPC number
My lord, the criminal petition number 813.
813-2012 and Miss M. Begum.
784 oblique.
Learned for the learned counsel for the petitioner in criminal petition number 784-2012 and Miss M. Kumari, learned standing counsel, CBI for in both the above noted writ petitions. Hizat Awsar has filed, the CBI respondents have filed an affidavit in the matter and therein have brought on record the fact that both the petitioners the petitioners in both the above noted criminal petitions have, during the pendency of the present proceedings, passed on, no dates, passed on 11/12/2019. And what is the date of the other one? Both 11/12/2019 and 11/12/2016 respectively. Full stop. Accordingly, the learned counsel for the CBI.
19.
Huh?
For Adhar Kumar, 11/12/19.
11/12/19 and this one is 11/12/16.
Regard to Bhattacharjee,
It's 11/12/16. Page 39.
11/12/2016.
16, huh?
Bhattacharjee.
11/12/2019 and 11/12/2016 respectively. Full stop. In view of the above, the learned counsel for the CBI has submitted that, learned standing counsel CBI has submitted that the matter has become, the present criminal petitions have stand abated, full stop. They said submission is not opposed to by Mr. the learned counsel for the petitioners. In view of the above position, development taking place in the matter, both and the death of the petitioners occasioning during the pendency of the present proceedings, both the criminal petitions being number stand abated. Stand closed on being abated.
I can-
I have the item of 35.
Who is for 34?
I am checking, my lord. Actually, other advocate has been engaged.
S. Sharma, SN Odhyapak. Mr. T.J. Mohanto. S. Sharma, SN Odhyapak.
SN Adhyapak. Yes.
Who is senior counsel S. Sharma or somebody else? Same issue in all the three. You are an employee.
Yes, yes.
In the first one is the person who has obtained that passport. And the other three are
Employee.
Primal, Shivnarayan and Rupak Kumar Gugoi are employees.
Yes.
Hmm?
I am Thirumal.
What to do?
Matter should be started by the person
then
everybody, same thing.
because
Can you just find out if Mr. S. Sharma, Madam, we'll take it up after some time. And Mr. T.J. Mohanta also.
And
Where is he? You don't know means?
Yes, the Angus matter, Your Lordship.
M. Singh, what is his full name?
I will go through the file and collect the phone number. I will call him.
Take it up after some time.
Hello.
Mr. A.K. Purkhaisto. M.K. Mojumdar. Okay. Yes, Mr. Mojumdar.
But I have, we have facing biggest problem. We could not trace the file.
This case, no problem.
No.
If you have
what
any
I-
problem, we'll appoint an amicus. There is no
What I
problem.
not to.
No adjournment. Other than that, anything.
What I submit that we may be allowed to go to the last occasion also we prayed with the court.
That daily,
that we-
that prayers are there. If you have not gone through, Mr. Majumdar, this court cannot keep this matter of 2013.
No, we are to do, but only thing that
Today.
we may be allowed to go to the file at least because code we missed our file and even the lower court record also we could not collect. So last occasion we.
You go through the file, go through the evidences of PW 1, 4 and 5 and 323 is the,
Yes.
well,
Yes.
that'll do. We'll take it up after few items.
Can it be at 2? I will go through.
Today.
And Mr. Purugase also.
Mister, we'll not disturb
we
the
will
flow.
Do it. But we
You
are-
do it today, now,
Yes,
after
today,
some time.
but-
After the item number 44, this matter will be called up. Or you be here, we'll pass orders. There is no problem.
I have mentioned Lordship on behalf of RS Mr. Lordship. Only for the
No
day,
mention, no mention,
Only for the day, Lordship.
no mention. You be here.
Can the two?
Yes.
But LCR,
Give the LC. If this is the thing, we will come up after 2 hours. You go through the files. Why should we sit here? These whole matters have been listed with the clear direction that these have to be taken up for disposal. And we come prepared. I spend my night. Then, Mr. Borua,
my lord.
if you come to the judgment at page 13, internal para 14,
Yes.
just give you what it is exactly.
Husband is not here, my lord. So,
Second copy not hanging here.
these are criminal appeal, my lord. Go
Judgment is not there.
Yes, it is there, my lord.
Come to 14.
Yes, my lord.
Here the thing is, I take note of the fact that so-and-so in his case stated that due to lack of time and lack of communication, these articles could not be weighed. Though it has been stated that about 100 grams of opium were recovered. Since
The-
it has come to evidence
Lord,
that
may reading the paragraph number of
14,
paragraph 14 of the judgment, my lord.
judgment.
Yes, my lord.
So it is said that the Department of Ways and Measures could not weigh because the seized article was not weighed. So about 100 grams it was said. Now he goes and says that 25 grams is the small quantity above and 2.5 kg is the commercial quantity. And then goes and does it. Now, if you come to the evidence of PW1, have you got it? You see that he says that around 100 grams were got on a weighing scale, weights of 50 grams, 20 grams, 10 grams, and 5 grams were also found wrapped in a cloth.
My lord.
1 hookah was also found. All these things were recovered in the presence of the witnesses. 2 packets of 5 gram each were prepared and sealed in presence of witnesses and accused. this was for sending to the FSL.
FSL, my lord.
So 5 grams, 5 grams. Now you take up the FSL report. That is, it is Exhibit 3. Last, I think, last. Exhibit 3 you have seen? Type copy. Huh? Mr. Burwa? Last, towards the end it is. The exhibit file is there.
My lord.
Now, you see the quantity that was received for examination.
0.5 gram.
So here it was 5 grams, and where did that 5 gram go? Petitioner has not argued it, but still appellant has not argued, but that is something which is coming out from the records.
1.5 gram. my lord.
1.5. But the evidence of PW1 is he had taken 5 grams, 5 grams.
Additional 5 gram.
Two, where is that packages? Whether it is the same, and the FSL, nobody was examined. The report was given by the investigating officer, that is PW1. Is it not a vital factor? That is why I asked you, Mr. Counsel, prepare your case. You do one thing, just go through it once. If that be so, I don't think so this can survive.
No, my lord, only one question, my lord. Give me the 5 gram was sent for FSL, my lord. The report, my lord, it is
Only 1.5
it is
gram.
1.5 gram.
So where is that 5 gram packet gone? Whether it's the same packet that was examined?
That has not been challenged by your, my lord.
Be that as it may.
Question is that, my lord, the FSL report, it gave positive test for, my lord.
Positive test, I know,
For
but
my lord,
see the variation. That there has to be an explanation for that. There is no explanation.
My lord, there is a forwarding, my lord, while setting the FSL, my lord.
That has not
That-
been exhibited.
That I am searching, my lord.
That is not been
getting-
exhibited.
That I am not getting, my lord.
That is not been exhibited. Even if the forensic expert had come and made a statement that, okay, we had got 5 mg, 5 grams, but we took out only 1.5 from there and made the test. That is also not there. You just go through it once. We'll take it up after some time. Mr. Counsel, you're a young man. This is not expected.
Hearing on behalf of RS Mistral.
Whoever it is. Ask Mr. Mishra to be here.
Lords,
Yes, Mr. Mahmood.
It has been shown the top of the list, but it has not come for hearing measure. That is why I did not prepare.
Now you prepare. Together we'll prepare. And there is another quoting there, top of the list, no adjournment. If you want, you can make an application to the registry bar that these matters should not be listed. We'll be happy. But once it is listed before me, you have not
No,
circulated
I
a
understand
circle.
that, but it-
I
it
spend
is
my night.
not listed for hearing, that's why my
No,
lord.
today itself. Mr. Mahmood is enough. Mahmood can do it
Then
anytime.
lord, you kindly take it at 2 p.m., 3
Okay.
p.m.
To 2 p.m.
2 p.m. other
No,
matters.
2 p.m.
In the file, my lord, I can, like, somehow.
অলপ পিছত মাতিবা এনেই এইবোৰ লিষ্টিং কৰা মানুহ নাথাকিলে কিডাল হ'ব From tomorrow onwards I'm not coming ready. Why should I spend my night? Nothing is there. All forceful conclusions. This is an appeal against acquittal. I think the learned court below, both the trial court and the appellate court have dealt with the matter in the manner required. Detailed. What had happened is that the trial court had convicted him. Then the matter was taken up on appeal. Rightly so interfered with. All of Pishat Matiba.
Give me 5 minutes time, Mother. I don't have the brief, Mother. I'll bring from the. I mean, sorry.
But today, Mr. Counsel, this court will sit till 8 o'clock, but all these matters will be.
I'm coming, Mother. I'm coming. I'm sorry, Mother. I'm coming.
List this matter before any other bench without me. Ekorba matter. No, 34. 34 matter.
Kindly allow us the files to.
You give Papa ki file give it on. This is a CBI matter, you're not there.
Yes,
Madam is there.
43.
So other matters you take. Yes. Who is SN for the item number 34?
I checked, but there is no phone number. And I will take instruction from my assistants to collect the phone number.
No
from
need.
that
What we do is, we appoint you as the amicus curiae in item number. You are appearing in item number 35.
Yes.
We appoint you as amicus curiae in 34 and 36. 36 and 36. Any problem? Same argument. You are appearing for?
I'm 34. My counsel is on legs. Can we?
Oh, he's here. 34 and 36.
34. I'm for 34 and 37.
37, sorry.
37.
Then Mr. Monto is there for, okay, fine. We will hear him. Then we'll take up. Yes. Madam, you are ready? You are for item number
35.
35. He was subsequently brought in.
Hello.
Initially, he was not there.
Earlier, Mr. S.K. Borkotaki was there. So I'm not well acquainted because he's not well. So some assistance may be needed.
We are here. We would have loved to hear, sir, but that now that you are here, 2013 matter, we will continue with the hearing. Tomorrow, keep answer to the correct material. Dairy only, okay. You are
And next, I am Thirmal Talukdar. I am the LCD, that is clerk at passport office. And judgment, in my case, judgment is at page 14, Annexure 1.
okay. Judgment is the same in the all the three cases.
My lord.
4 cases, huh?
So FIR in brief is that one MS Sera, that is the accused number 1, and in item number 34, who is the proprietor of MS Mahindra Tank Private Limited, entered into a criminal conspiracy with other accused. That is Shiv Narayan Mazumdar, the then superintendent, R.K. Gogoi, senior assistant, and S.N. Mazumdar, dishonestly issued a passport. So initially I was not there. So thereafter, due to, as because initially the file was put before me, so I brought into this case, my lord.
File was put before you. You received the application form.
That
You
is
verified the documents. You verified the documents along with its originals, and then you put it forward for the further
That is my
examination.
Wow. and that is my duty also,
Hmm.
entrusted to me. Thereafter, what happened, I have no idea or I have no role. So if you go by the fact, my lord, the allegation is that this person, MS Sarah, obtained the passport in the name of another person, that
Ramnath.
is Ramnath. By
Hmm.
forged and fabricated documents.
Hmm.
The documents are first documents is matriculation certificate, Haryana School Education Board,
Hmm.
issued in May 1965, proof of age. The second document he produced, fake employment certificate purportedly issued by Messrs. GL Lamination,
Hmm.
Zoo Narengi Road.
Hmm.
That is second document
Hmm. Hmm.
as address proof.
Hmm.
And thereafter, my lord, another fake certificate purportedly issued by the president of Marwari Yuva Manch, Fancy Bazar, Guwahati,
Hmm.
stating that Ramnath of Guwahati was being sent to Philippines as a member of cultural program.
Hmm.
So in this case, what my lord, have seen that the person MS Sarah is a NRI. So as per the allegation, he came to Guwahati, made the application in the name of Ramnath, and as per the allegation, some departmental lapses are also there, because one thing as per the allegation, it is to be sent to the police for verification, but that was not done. So if I present, so this is the basic, and if my part, my lord,
Hmm.
in the page 15,
Hmm.
para number, second para, my lord, during course of investigation, my name is there,
Hmm.
and fifth line from the bottom, my lord.
Hmm.
It is stated by the IO of the charge in the charge sheet that the investigation reveals that accused Trimal Talukdar filled up and accepted the said application form and removed the letter addressed to SP Guwahati and IGSB for verification
So
from the file, knowing fully
the
well.
other part we can understand that you got an application form, he gave a original, you verified, fine. But what about this? That the police verification was scuttled
My stand is
because the case of the prosecution is that if this had gone to the police and it is clear that this application form never went to the police for verification.
Right.
If it had gone, these factors would have come out.
that is correct.
But you prevented. What is your stand on that?
But my first stand
So,
is
ma'am,
that,
that is the area where he is there.
so my first stand is that my duty is limited to acceptance of the application, give a file number and forward it to the other persons. And in the cross examination also that is established, madam. If we go to the cross of accused PW1,
Hey, to the answer.
it is well established, madam, PW1. That is one Indreswar Basumatari.
He is the IO.
No, madam. He was the LD assistant. Subsequently,
Rest of early assistant, huh?
and subsequently was removed from service in the year September 2001.
Because why that removal, that is not there.
That is not there, madam. So, but his statement and allegation against me or the other persons is questionable. W1. Or female type.
Sini to me. PW1. Okay.
May I read the first allegation put by me by this PW? Then we can go to the.
No, I've seen your allegation. That has been dealt with by the learned trial court also.
But in that this PW1 only says that exhibit 1 is the signature of Srimal Talukdar. I know Miss Srimati Anjali Thakuria Das. She was the daily rate worker, dealt with personal particulars of form. The aforesaid application was also signed by Anjali Thakuria Das with her seal on 29th of March 1995. He had mentioned that PP form was issued. Exhibit 1-2 is the signature of seal and seal of Anjali Thakuria Das. So in this PW, it is not alleged.
Go ahead.
I can identify her signature as I was working with her. I know Srimati Rupa Kumar Gogoi. He was also an assistant in our office. He was dealing with personal particulars form. He also signed on the aforesaid application form dated 29th of March 1995. I can identify his signature as I was working with him. Exhibit 1/3 is the signature of Said Rupa Kumar Gogoi with seal. It was the duty of the dealing assistant to sign the personal particulars form, forwarding letter, and Rupa Kumar Gogoi, being the dealing assistant concerned, was responsible to check and sign personal particulars form, file and forwarding letters. I also signed on the aforesaid application form dated 2nd of May 1995 with the seal. I signed as index warning and made endorsement to the effect under my signature. Exhibit 1/4 is my endorsement with signature. I did not find anything adverse against Said Ramnath at the time of signing the index warning. This is important, my lord. After going through the page 2 of aforesaid form, column number 8, I have to state that it bears the address of the applicant as Sivasi, Gurgaon, Haryana. The applicant also filled up his present address as Maligaon, Kamakya Gate, Guwahati, Kamrup, Assam. After going through the column 10 bracket A, I have to state that it was filled up that the name of the father of the applicant as Amarnath. In column number 10B, the name of his mother is shown as Jamna Devi. And column number 10C.
Madam, you can have your seat. You can have your seat. Relax.
Here's the name of his wife as Anita. After going through page 4, column 17 of the aforesaid application, I have to state that it bears the same address as above. After going through page 5 of the aforesaid application in column 21, I have to state that it also bears the same address as aforesaid. After going through page 6 of the aforesaid application form, I have to state that I have found the signature of Rupa Gogoi dated 3rd of May 1995. In this note, he had recommended for issuance of passport as above and marked to the superintendent. I can identify the signature of Rupa Kumar Gogoi at page 6 of the aforesaid application form and endorsement with handwriting wide exhibit 1-5. I have also found the signature of Shiv Narayan Majumdar, superintendent, at page number 6 dated 3rd of May 1995 with his endorsement. He made his endorsement regarding fulfillment of columns number 20 and 22, which were incomplete. Exhibit 1/6 is the said signature of the said Shiv Narayan Majumdar with endorsement. I can identify his signature as I work with him. I have also found another signature of S.N. Majumdar at page number 6, which seal mentioned the passport number 305506. That means on the same day, 3rd of May 1995, S.N. Majumdar granted the passport with endorsement. Exhibit 1/7 is the signature of S.N. Majumdar. I also found the signature of Ratan Kumar Tamuli, LD clerk, and passport writer in page number 6 of the application form, who wrote the passport number this with the still dated descendant. Exhibit 1/88 is the signature of Said R.K. Tamuli. After his signature, the superintendent S.N. Mazumdar put his signature right, Exhibit 1/7. After going through the first page of the aforesaid application form, I have found that file number descendant written on it, showing that the date 31st May 95, it was made by Trimal Talukdar. I can identify his handwriting. I worked with him. Exhibit 1/9 is the said file number written by Trimal Talukdar with his handwriting. I have to state that date mentioned above, 31st May 95, indicating file number descendant, actually should be the date of receipt of application. That is 3rd of May 95, according to the rules. Exhibit 2 under objection is the photocopy of the mark sheet of Haryana Vidyalaya Shiksha Board bearing number this, mentioning the roll number this in the name of Ramnath. I found the signature of Trimal Talukdar dated 29th of March 95 at the same Xerox copy mentioned the original scene.
You were accused number?
Accused number, my lord, 3, A3.
Okay, go ahead.
I can identify his handwriting. Exhibit 2.1 is the signature and handwriting of Trimal Talukdar. The mark sheet was issued on 26 May 1965 by Haryana Vidyalaya Shiksha Board, and it was submitted by the applicant with the application form for passport. Exhibit 3 under objection is the photocopy of the letter head of Marwari Yuva Manch dated 27th of April 95 nominating Ramnath of Guwahati. This also bears the signature of Trimal Talukdar dated 28 April 95 mentioning original scene. I can identify his signature and handwriting on the aforesaid letter head. Exhibit 3.1 is the signature of Trimal Talukdar. Exhibit 4 is the certificate issued by GL Lamination dated 3rd of May 95, bears the address of Ju Narangiri Road, Saheb Tila, Guwahati in the name of Ramnath. It bears the file number descendant, which was also written by Trimal Talukdar on the first page of the application form. I have found that Rupa Gogoi recommended for issuance of passport. According to the rules, application form should be accepted along with all necessary documents. If the application have any deficiency, the applicant should be asked to meet up the deficiency, and only after fulfillment of the deficiency, the application should be accepted. But after going through the application form with conclusors, I have found that the application form was submitted on 29th March 95, but other enclosures were attached with the application later on. As Exhibit 3 was received on 25th of April 95 and Exhibit 4, the letterhead, was issued on 3rd May 95. After the receipt of application form passport, that is 29th of March 95. So in this matter, the allegation against me is, the projection against me is that I have received the application, checked the documents, Xerox copies with original. Thereafter, I have marked as seen with original and put the file number. So there is no allegation regarding I have not forwarded to the police or anything else, my lord. So if we go to the cross-examination part, I was promoted to LD assistant in the year 1990. I was suspended from my service in January 1998, and I was thereafter dismissed from service in September 2001. So this makes the statement of the evidence of the PW1 under some clouds, my lord. I gave my statement before CBI on 24th March 2002. At that time, I was out of my service. While I was serving as LD assistant, I had to check the index. So I know about index. I also have to verify whether the application had filed earlier also. For the said reason, I had to check up the father's name of the application, address, photographs, etc. I had no other function except the aforesaid functions. I was not authorized to verify any register except one. It is not a fact that accused Thimal Talukdar used to receive the application, verify it, and finally issue the passport. His only duty was to receive the, this is important, my lord. His only duty was to receive the application form of the passport. There were other persons in the office who checked the documents and enclosures with the application form for issuance of passport. At that time, one Mr. Gogoi was the regional passport officer, one Mr. Nath was serving as superintendent, one Mr. Deuri was serving in the capacity of LD assistant, and there were other persons who used to check and verify documents along with the application. Exhibit 1/4 is my signature where it is written that index warning checked. So
Index warning check is that whether the central government has put him in a negative list. There is a negative list that they have to check.
the stamp was put on 2nd of May 1995 with my signature. Apart from my signature, there are other signatures, one belonging to Mr. Thakuria, who was in charge of the passport form. Accused Thimal Talukdar put the signature upon the rubber stamp case received. Accused Thimal Talukdar never mentioned in Exhibit 1 about anything except receipt of the application. So it is clear, my lord, I have never mentioned anything except this, my lord.
How many witnesses were there in total?
14, my lord. One
Cross witness, court witness was also there.
one court witness, yes. So here, my lord, the allegation against me, to that I have received the application, put the file number, and verified with the original, and received the case amount, that is 300. Exhibit 2 and 3 are the photocopies, and I have not seen the originals of Exhibit 2 and 3 before the Honorable Court today. So some documentary lapses or evidence are also there, my lord. Some copies were not produced in original. The signatures were not properly forwarded to the handwriting expert to verify whether to corroborate with the evidence, my lord. That is there. In Exhibit 1, the page number 6, one of the signatures of applicant was cut out and it was taken by scissors. I mentioned before CBI that Thimal Talukdar was the counter clerk. I am the counter clerk, which means that he used to simply receive the passport application along with the application fee. It is not fact that whatever allegation I had made before this honorable against Thimal Talukdar are not. Well, here in the middle part of the cross-examination, may I bring the kind attention there. It is not a fact that accused Thimal Talukdar used to receive application, verify it, and finally issued the passport. So when the suggestion was there, he accepted that it is not all my work. My work limited to only to receive the application and the fees, and to check the original, verify it, query it, if anything, that would be made by the other officers. Cross of PW1 MS Sarah is there.
That is not
May I-
required.
MS Sarah is out.
Then you go to PW4.
Right.
Sachindra Mahapatra. Sachindra Mohan Mahato.
There is nothing against me in that.
There is something against you there. Accepted application, although there were several irregularities.
PW4, my lord.
4. PW4, you go to
Sasindra Mohan Mahato.
second page. Second paragraph, third paragraph, second paragraph.
After going through
Exhibit 1.
After going through exhibit 1/1, I have to state that it is the signature of Trimal Talukdar who accepted the money of rupees 300 as passport fees on 29th of March 95. And he accepted the application through, though there were several irregularities with the enclosures as mentioned above. At that time, one Indeswar Bosumotari was the index clerk. So he also forwarded the matter to that PW1, my lord. But I cannot identify the signature of said index clerk as he never worked with him and as I joined in service 1999. But I know that the said index clerk Indeswar Bosumotari had been dismissed from service. After indexing, the file will be sent to the dealing assistant. And at that time, Rupa Kumar Gogoi was the dealing assistant. It is the duty of the dealing assistant to check the documents properly, and if he finds everything okay, he will endorse the file to the passport granting authority. After going through exhibit 1/5, that is remark of Rupa Kumar Gogoi, I have to state that he did not point out the irregularities defect of the documents furnished and endorsed to actually it should be the passport granting authority, that is superintendent who was authorized to sign the passport, making note that superintendent may grant passport. After going through exhibit 1/6, remark of the then superintendent Narayan Mazumdar, I have to state that the superintendent remarked that column number 20 and 22 incomplete and call for completion. I can identify the signature of Rupa Kumar Gogoi. The passport was granted on 5th of May 1995. After going through the first page of the application form, it seems that the passport had been received by one Ramnath on 4th of May 1995 by the exhibit 1/11. So, although it says that some irregularities, what kind of
Gazetted officer's signature.
that is not leveled against me specifically, my
Yes.
may I read, my lord, subsequent?
You come to the first initial part. These are the documents.
I joined
After the A, B, C, D.
as proof, address
After
proof.
going through the enclosure of so-and-so, I have to state that exhibit 2, which is the age proof certificate, was not properly attached by a gazetted officer, but as per rule, it should be attested by a gazetted officer. After going through the certificate regarding residence, so-and-so prospect for, because the address is not properly mentioned.
So, my lord,
So the form that you had accepted was not complete in all respect. That's the allegation against you. So the other factors coming in, the conspiracy.
but my reply against this would be, I am the receiving.
Okay, we'll take your reply, make a note.
My lord.
Then what?
Then, my lord, after going through column number 8 at serial number 1 and 2, exhibit 1/12 and 1/13, I have to state that the address was not properly mentioned as the place was only intentional and no house number etc. is given. PIN number etc. were also not mentioned, but as per rules, the details of the address should be mentioned there. So the police verification may be done properly. After going through exhibit 1/14, column number 17, the application form, I have to state that the address is not properly mentioned there, only same as above in mention is mentioned. After going through column number 10, exhibit 1/15, I have to state that the application filled up his father's name, mother's name, and wife's name, etc.
After going through column number 21, the application form, that is 1/16 and 17, I have to state that the name of the person required for reference are mentioned there without any proper address. After going through exhibit 1/2, I have to state that there are overwriting in the date mentioned as 29th of March 1995. As per procedure, the police verification is to be sent with forwarding letter in which the assistant should put his signature. And at that time, Rupa Kumar Gogoi and the assistant something is missing here.
You come to the end part. You come to the end part of his name, examination in chief.
There is an index section.
No, after going through exhibit 2. Before the cross
Yes, sir.
part.
After going through exhibit 4, the address certificate, I have to state that the certificate was issued on 3rd of May 1995 as, but the application for the passport was submitted on 29th of March 1995. It means that address certificate was not submitted with the application form and it was submitted on 3rd of May 1995. That is date of issuance of passport. So as per the rules, it is the defect sorted out because the address certificate was not enclosed as at the time of submission of application form. And without the address verification, the application form of the passport holder was processed. The date of issuance of address certificate, that is 4/1.
So before that also, the application form was given on 28/4/95, but the mark sheet and the address sheet were received on 3/5/95. That is the date when the passport was issued. So how could you, that's the allegation, how could you have forwarded the application as complete in all respects? Okay. Anything else?
Not against me because
Against you, because that is received by you. You should be receiving by you. These are all against Trimal. I have to state that the mark sheet was received on 29/3/95 by Trimal Talukdar and he made an endorsement that so-and-so. 2-1, I can identify. Exhibit 2 is the mark sheet. After going through Exhibit 3, I have to state that the document was received by Trimal on so-and-so, indicating so-and-so. After going through Exhibit 4, the address certificate, I have to state that the certificate was issued on 3/5/95. So that certificate was not there on 29/3/95 when you received that passport application. Got it?
Well,
Hmm.
may I reply against this point, my lord?
No, we'll come back. We're just collecting it.
My lord.
Then what is there?
May I come to the cross part, my lord? Cross examination. I have never seen Mahendra Singh Sera. I do not
Okay.
know anything.
So here nothing is there against you.
Right.
The next one would be PW8.
Eight, my lord. Ratan Kumar Tamoli.
He is the passport writer.
Where did the, my lord, evidence?
Read it. Something is there. Tell me.
Today I have appeared before the court on receiving submission. I joined passport office this and that. Working. I am acquainted with the procedure of obtaining passport from the passport office. He stated the elaborately regarding the stage, my lord. First, the applicant will obtain the form from the passport office. Thereafter, the applicant is informed about the required documents. although the same is written in the form of obtaining passport, thereafter the applicants will submit his filled up form in the counter cash receipt. So here I come, my lord. Thereafter, counter clerk will see whether all the particulars in the application form are correctly and duly filled up. So my thing is to check whether it is duly filled up. Photograph, age proof and address proof, and if government service, there is no objection certificate from the concerned department. Thereafter, a file cover is prepared, that is me, madam, by the record sorter of the passport office. Thereafter, personal particulars form which is to be sent to the police, duly filled up by the concerned staff. That personal particulars form was also filled up by our peon. At that time, situation was there, my lord. Here it depicts. As because we have shortage of staff. During 1995, Anjali Thakore was the staff of our office who was assigned to duty of filling up the personal particulars form. Because in the passport office or even now, my lord, even if we fill up anything, the normal persons, the citizens take the assistance of the advocates or clerks, my lord, fill up those documents. After the personal particulars form is filled up, same is signed by the dealing assistant. During 1995, Rupa Kumar Gogoi was the dealing assistant of our office. I know Rupa Kumar Gogoi, who is my colleague, his assigned duty. So far I know was signing of personal particulars form and put up the concerned file before the passport issuing authority.
In the cross, he says that your duty was only to receive that.
That is correct. The evidence also stated the same thing. So thereafter, what happens? Anything or anything, any allegation? I am not in the picture, my lord.
Okay.
So if we go to that PW also, earlier one, then also we can say, my lord.
There is another allegation that you had also put in particulars in the application form.
But no, as so far, no.
What are the findings against you?
Hello? Order against me is page 46 of my
Para?
punishment. Punishment.
No,
part is
not
page
punishment.
46.
Finding
Finding,
is.
my lord.
You can come to internal page 21, last paragraph.
PW 1 and 4, my lord. PW 1 and 1, 4 and 7 and PW 8 are all where are the employees of the passport office. They are evidence of disclosure, disclose that exhibit 1 is the filled up passport application form of in the name of Ramnath. According to PW 1, I'm the 4, my lord, I'm sorry. Accused 4, Trimal Talukdar as counter clerk received the said application with the prescribed fees of rupees 300. PW1 has identified the signature of A4 as exhibit 1/1. At the relevant time, accused 3, Rupa Kumar Gogoi was dealing with the personal particulars form, and he also signed the exhibit 1 application form wherein exhibit 1/3 is the signature. It is stated by PW1 that the dealing assistant Rupa Kumar Gogoi was responsible to check and sign the personal particulars of PW form. PW1 has also identified his own signature as PW1/4. According to him, he signed as index warning and made endorsement to that effect. That accused Trimal Talukdar accepted exhibit 1 application form along with an amount of rupees 300. These facts also revealed there from the evidence of PW4. Corroborating the PW1, it has been stated by PW4 that at the relevant time, Indeswar Basumatari, PW1 was the index clerk and accused Rupa Kumar Gogoi was the dealing assistant. It has been alleged by PW4 that Hirmal Talukdar accepted the Exhibit 1 application form, though there were several irregularities and also though Rupa Kumar Gogoi was to check the documents properly. But it is alleged that he did not point out the irregularities defects of the document furnished. So regarding the defect, the allegation is against Rupa Kumar Gogoi. My allegation is I have received the document till so far now, my lord. Rather, he endorsed the passport granting authority, the superintendent. PW7, Anjali Thakoria in her evidence has deposed that when Exhibit 1 application was put up before her, she prepared the personal particulars form for sending the same to the SP city. So Anjali Thakoria accepted that the form was prepared by her. Before her, she prepared the personal particulars form for sending the same to the
What is the
SP.
penalty imposed upon you? 8 to file due.
2 years rigorous imprisonment with 1 year's mileage. 3 months
35.
in default.
Page 35.
At 46, my lord, of the
Page
of my
35.
appeal.
Serial number 35.
Internal
Hirmal.
page 35, my lord.
Hirmal Talukdar.
35, last page, my lord, of the judgment.
Your sentence was passed separately.
Last page, my lord, sentence is there, my lord, 46.
Same sentence for all. I mean the employees.
My lord.
2 years, rigorous imprisonment, fine 2,000. In default, 6 months. That is under section 420.
Yes.
2 years, rigorous imprisonment, 471.
They do it.
Read with 13(2) of the PC Act. 222, but concurrently.
Concurrent.
Okay. So, where is the final conclusion against you?
Page 41 of my appeal, my lord. Second paragraph.
Internal page?
Internal case, my lord, 28.
Huh?
28. In the present case, the signature writing accused carried, my lord. In the present case, the signature writing of accused Hirmal Talukdar was sent along with Exhibit 1, 2, and 3 to the handwriting expert. The said expert has been examined the CW1 in the present case. As reveals from the evidence of CW1 after comparing the question writing with the specimen writing, Hirmal Talukdar, he arrives at the conclusion that the person who wrote the blue enclosed writing stamped and marked S1 to S70, the writing of Hirmal Talukdar wrote red enclosed writings, and this. There is no evidence or explanation from the defense side as to why accused Hirmal Talukdar filled up some of the columns Exhibit 1 application form, filling the Exhibit 4 forged document 3rd of May 1995 on the day of issuance of passport, and its acceptance also pinpoint to the involvement of the accused in the conspiracy. And final conclusion, my lord, is page 31. Combinedly,
Conspiracy was 420 in consult.
combining the all allegation against the all, my lord. And 32 is accused number 1. Yes, because accused number 1, allegation against accused number 1 is true.
Okay.
Hence, I am also.
What is your submissions?
My first ground would be, my lord, that what my duty rested upon me in the office is of that, my lord, receiving authority. If anything happens thereafter, I cannot say anything. It is not, it is beyond my duty, and I have no hold over those things, my lord.
Hmm.
Now, secondly, my lord, in the evidence part also, although in the judgments, there are so many things against me said that I am the person who did not forwarded the matter to the police for verification.
That we leave it.
Yes, that is not there, my lord. Although that is one of my.
But what about your writing of in the application form?
In
No
my,
explanation in 313.
in my defense statement, my lord, I have simply denied it.
You
First
in
of all.
313 you only denied it.
Yes.
But
There-
why did you write? There should have been an explanation to that effect. No explanation.
My lord, from the evidence of PW, 8, I think, he explained that there were shortage of, even if we, for some time, we accept that these writings were of the accused number 4.
No, accused number 4, those things have to be filled up by the applicant, not by the official people. You filled it up. That was sent to the forensics expert. He concurred. And you have not even crossed him to that extent. Only said whether you are in a sitting position. You have not denied. Even in 313, you have not denied that. Then next submission.
Well, against that, my lord, one one witness stated that at that time situation was there, different. Shortage of staff was there, and all persons cannot do the all things. For that purpose, my lord, he was authorized to do.
So that is
things.
different. That is with regard to sending it to the police. That we forget.
My lord, PW 8. If we come to this statement, thereafter personnel particulars form which is to be sent.
No, I'm not on the personal particular form. I'm on the application form itself. Because therein your handwriting is there. Why? What is your explanation to that? Okay. What about your receiving this address proof and the mark sheet after submission of the application on the date when the passport was issued? What is your clarification on that? In 313, there is nothing.
Hello, but PW 1 states that the address proof is proof and Marwari months something on the submission of that form. These documents were there. I received it, and I also seen the mark that seen with original. So their address proof is there, age proof is there, and this Marwari Yuva months that certificate is there. So thereafter, my lord, on the last occasion, there is no statement by any of the witness saying that I have received those documents, my lord. subsequently, my lord. At that initial stage, I received why I have been given, my lord. And after checking with the original, I have made one file and forwarded it to the dealing assistant. So thereafter, if anything, any document is there received by me, that is, I don't think, my lord, there is any statement against me by the PWs, my lord. So far I have seen, my lord. So only says that certificate was submitted subsequently. There is no allegation that I have received those documents, my lord. But one thing is there that address proof, age proof, and this Marwai Yuvaman certificate, I have received, and after have seen the original certificate, I marked the remarks that seen with original. So it itself shows that the documents submitted along with the application I received. Thereafter, my lord, who received, if anything,
Okay.
that is not there.
Any further?
And PW1 also specifically stated that my clerk is to receive and, my lord, not verify, to check whether the original is there or not, or the columns are filled up or not. Nothing else, my lord. So secondly, my lord, if those correction, if anything correction was there, whether it was subsequently dealt with or earlier dealt with, because I am not, my lord, conceding, but many cases when we go to a office, or even today, my lord, even today I go to the bank, there are many elderly person or other persons who come just say that kindly fill up these matters. And in the bank, we can generally see those things, my lord, that those persons, the clerk or receiving or the what is called even the general manager also sometimes helps those persons, even today also, my lord. We cannot say that those things are never in practice by any offices. One thing is that the form should be filled up by the applicant. That is the rule, but it cannot be, my lord, mandatory, because that can be filled up by his, my lord, relatives also. Signature is the important thing. And sometimes if some confusions are there, the official also does the same thing, my lord. Because in the public sector things or other offices also, we even see those practices that if something is missing, even, my lord, I have seen nowadays also, the persons 50, 60, 70% cannot, my lord, fill up the form for opening a bank account. So either they take the help of any, my lord, family members who knows the thing, but there are so many options in passport office, bank account, opening of a bank account, or things are there where even today, my lord, the applicants always, my lord, take the practice or the help of either bank official or any person there standing, my lord, for their own things. In other offices also, I have seen that practice, my lord. Even if I go to the bank for obtaining a loan, the whole, my lord, forms or things are filled up by the bank. I have to only put the signature. That does not seem to, my lord, we can assume that there is any malafide intention or anything else. But there is not a single, my lord, statement by the PWs, as per I, my lord, have seen. Because I have already stated, my lord, Mr. S.K. Borkotaki was actually earlier. Whatever I have seen from the record, but I have seen that it was done subsequently, my lord. Even if I have at the time of taking or receiving the application, even if some lacuna was there or sometimes the persons cannot say what to fill up or properly fill up the things, the official actually, my lord, helps those persons, my lord. So it does not mean that if thereafter, after I have received the application, I have forwarded to the dealing assistant. Thereafter, subsequent development has been, when it's taken, At that stage, if I made some changes or anything else, then the matter could be in a different perspective, my lord. But in the whole case, my lord, CBI has failed to state that those things were subsequently done.
Hmm.
So even if we assume that
Hmm.
the things are done by this accused 4, then also we can assume that in his capacity, under his authority, and whatever has been entrusted to him, my lord. So there is no specific allegation
Hmm.
or anything, my lord, in the whole case,
Hmm.
or even the handwriting expert also did not say that it was after 3 months, 4 months that these things were, my lord, put up.
What do you say about this GA lamination certificate? You have said that this was along with the document, it was there, but it is dated 3/5/95. Okay.
My lord, exhibit 2 is the Haryana Vidyalaya Shiksha Board I have received and marked as original sin. Secondly, my lord, Yuva months dated 27th of April 95,
Hmm.
original sin.
Hmm.
Exhibit, my lord, PW1 page 3.
Hmm.
Document I have received with the application.
Hmm.
And GL lamination dated 3rd of May 95.
Ah.
But
How come?
But that is not.
That was subsequently inserted.
But it does not say original sin by me. That is important, madam. Page number 4. Is one also aspect, madam. Those 2 documents, Xerox copies, original sin, that is.
No,
one.
this is the original. This is original. This is not a Xerox copy. This is original.
I have to check, my lord, whether it is original or not.
It's original. It's here.
The PW1, page 4 says that Exhibit 4 is the certificate issued by GA Lamination dated 3rd of May 95 bearing the address of Ju Narangi Road, Saheb Tila, Guwahati in the name of Ramnath. It bears the file number descended, which was also written by Trimal Talukdar on the first page of the application form. I have found Rupa Kumar Gogoi recommended for issuance of passport.
See, in the application form, the name of the mother, there is an interpolation made. Huh? This was question number 8 to the forensic science laboratory, forensic expert. He says, this is your signature. Then you come along. Question number 5, Reverie, place of birth. This was inserted by you. Gurgaon, this was inserted by you. 7, Maligaon, 8, so and so, so and so. Question number 7, that was done by you. Then okay. Anything more?
It some time to go through this expert, my lord, because I am not acquainted with that expert.
Okay, madam.
I'll take some assistance of my, if possible, from my senior.
We'll see, we'll see, we'll see. Yes, madam. So his basic duty was to receive the documents. and then to forward
He
it
is
to
he
the
is
authority.
Dealing clerk, your
Ah,
lordship,
then
counter clerk.
hmm,
The
application.
application form, whether it is duly filled, properly filled, and the due process of law. That he has ignored, doing that. And another question,
So that ignorance, is it with a criminal intention or was it just a lapse?
there are 4 public servant. None, it is a composite work. None of the public servant has and it has not sent
That he is not responsible.
another.
Maybe in the whole set he is also a part, but the police verification thing is cannot be related to him.
He has accepted documents, that is the certificate without
After the date,
after
3-5.
the date.
So
and
where
it
is
was
that
not
material
attested by
to
the
show?
gazetted officer.
Material to show that he had accepted 3-5-95 letter from GA lamination. What is the material?
Because it has to be included along with the form.
It is not there.
It is
The
not there.
application is on
So he is
29-3.
Supposed to accept it.
No, show me how because there is no endorsement of his on that letter. It's an original copy which is brought.
Said that he has seen the original.
Madam, that original could not have been seen on 29-3.
Yes, because it was not there.
Not there. So how did it come? What is the material to show that it came in subsequently? Who brought it in? Who allowed it to be brought it in? Because the file was not with him by the time the file had gone ahead and the file was ready for issuance of passport.
Going through the statement of the witnesses, your lords.
We can't just pinpoint.
Evidence on record that copy of mark sheet of
Madam, this will not do. Kindly point it out. We can't have the whole day here sitting for this.
Exhibit 4, the certificate dated 3.
You got my point?
Yes, your lords.
Just point out the.
GA lamination.
You please go through it.
GA
Please go
lamination-
through the files. Point out the relevant thing tomorrow, and then we will take it forward. We'll have it tomorrow. Item number 34 to 737. Heard Mr. Bish. DK Nath. लिखी दिबा. And who is appearing for item number 34? You are there? 34 and 37. Okay. Madam, against each of the accused, what is the material? Where it is? If you can give it to me in a sheet of paper, nothing like it. It will likha, 34 to 37. And Mr. TJ Monto is not appearing. Mr. M. Singh. So we'll have to appoint somebody else here. Mr. Borwa, any problem in appearing as an amicus in a CBI matter? You will have no problem. Item number 36, Lika. None appears for the petitioner on call. Also, this matter is an old pending one, and accordingly, this court proceeds to appoint. Yes, anybody volunteering? Miss B.S. Goel, learned. But tomorrow, madam, tomorrow we'll hear the matter at 2 p.m. Ms. B.S. Goel, learned counsel of this court, as the amicus curiae in the matter. Ms. Goel has gracefully accepted the said appointment. Full stop. Madam, can you give her a copy of the appeal in item number 36? copy. A copy Xerox koi dio paribane. Xerox koi dio paribane 36 or copy ata. Petition and judgment. Bele kuna lage. The court master will give you a copy of the appeal memo will be furnished. A Xerox copy of the appeal memo be furnished to Ms. B.S. Goel, learned amicus curiae by the court master during the course of the day. Also, registered to list this matter again tomorrow, 2 p.m. Full stop. Kali ki budbar niki. Thursday, 2 p.m. Day after tomorrow, Thursday, 2 p.m. Item number 34
My lord, regarding item
and 37.
regarding item 34, my lord, I have one information. First, I have to verify it, that Mr. M.S. Chera has expired.
We don't know. You
is
let
to
us know by
that is
tomorrow,
to-
by day after. 34 and 37, Mr. S. Sharma, S.J. Sharma,
Yes, yes, sir.
S.J. Sharma, learned counsel for the petitioner. Hearing remains inconclusive. Registered to list this matter again, Akuaya, 2 p.m. Along with WPC number 140, criminal appeal number 147, 2013. 35 would likiba heard Mr. D.K. Nath at length. Also, Ms. M. Kumari, learned standing counsel, CBI, is on has also been heard. However, her submissions have remained inconclusive. Accordingly, registered to list this matter again on Thursday date to deliver at 2 p.m. for further consideration. So 34 to 37, 2 p.m.
Yes.
And she'll give you the copy in the afternoon.
My lord, another thing.
Day after Thursday.
My lord, one problem. Day after tomorrow, it is 11th again? 11th, my lord.
11th.
11th, my lord. And my father's Shraddha is there, my lord. My father's Shraddha is able to appear, my lord, on that day.
Then tomorrow, 2 p.m.
Tomorrow I can.
2 p.m. Tomorrow.
I can.
Tomorrow, 2 p.m.
All right.
Any inconvenience? Ms. Goel, any inconvenience tomorrow, 2 p.m.? Or you'll have to go through the records. You'll go through today. Tomorrow, 2 p.m. Kali koi dia. Kali 2000. Matter. Not about this.
38.
Pair was already made, my lord,
And that was rejected.
rejected, my lord. That's why, my lord, I am going to renew my prayer. Fix the matter tomorrow, my lord.
I'm sorry, mister. This court, don't think that this court can hack up
I understand, my lord.
20, 30 appeals in a day.
My lord, and number one, brief was misplaced. Number two, my lord, he has.
And that is the prayer Mr. Purkhaista have been seeing in this application for long.
No, I am a handicapped, my lord. Not even speak a single word, my lord.
Why?
Because, my lord, to be frank enough, to be honest enough, I am having, my lord, 10 cases today. And
Okay.
all the cases I could not
We
prepare
know
by
it.
overnight.
We know it. We understand. We understand. We'll appoint an amicus curiae. Don't worry about it. You assess, you also, we'll hear you. We'll appoint an amicus curiae in the matter.
Tomorrow, my lord, nothing will happen, my lord, tomorrow.
Nothing will happen. The file will have to again come back. I'll have to again go through it. That's all.
Lordship, I already prepared.
You
the
should have given me a note yesterday that if you had any inconvenience, Mr. Purkhaista, Mr. Majumdar could have done it.
Sorry, I'm extremely sorry, my lord.
Man, need not be sorry. It's nothing.
Normally, I used to take care-
These matters pending from 2012-13. It's a bolt on
It's not,
our High Court also.
my lord.
I'm trying. That much I can do.
My lord, I used
Okay, on the prayer of Mr. A.K. Purkhaista, learned counsel for the petitioner, registered to list this matter on Thursday, 2 p.m.
Yes.
Thursday as the first item.
Yes, my lord.
Thursday. Right?
At 2 p.m.
No, first item.
My lord.
And if you don't come, if you're not here,
My lord.
okay. As Mr. Purkhaista is, we'll appoint a...
May I just make a request, my lord? I have an online case, on DB on Archal Pradesh. So, Lakshmi, can you take that?
At tomorrow, first item.
Tomorrow, first item. All right. Sorry, my lord.
Enagali,
Extremely sorry, my lord.
heard Mr. Purkhaista, A.K. Purkhaista, at length. বাদ দিয়া নালাগে কালি কাৰণে ৰাখা কালি কাৰণে ৰাখা
Sir, if your lordship does not accommodate, how can we survive, madam?
and if you don't understand the pain taken this side, how can this court dispose, do justice? Have Mr. Purkhaisto, I have a lot of expectation because when you come, we feel okay, our work is half done.
Tomorrow I'll do it. Sorry.
Huh?
Hello, may I go through the record, madam?
Anytime. Yes, have you gone through? What is there?
First and foremost, my lord, this is the my lord, FIR lost by the Excise Department. So on the basis of that, my lord, he has submitted, my lord, it's called final report, my lord. And PW1 is the, my lord, informant, my lord, and he has also submitted a search sheet, my lord. As the lordship's query, my lord, exhibit 3, my lord, the FSL report. I have tried to, my lord, found whether, my lord, any, but
No.
there is no forwarding, my lord. By the what is there in the, my lord?
So
There, my lord.
5 grams were sent, but the FSL report says
1.5.
only 1 point. What is this the same or it is something else?
There is also no cross-examination.
No,
my
no,
lord.
nothing.
They are also helpless, my lord.
So on that
So-
point, we have to interfere.
One submission may be recorded, my lord. The opium, my lord, which was recovered and seized, 100 gram. my lord. The test of-
Positive.
Positive test of opium is taken.
Hmm.
But from the my lord, conscious position of.
No, not conscious position. It was there in his tea garden.
House, my lord.
Be that not house, tea garden. Surrounding the house.
Gardens belongs to whom, my lord? That
Okay, fine. So in that point, because there is a doubt created whether that the material that was seized and the material which were finally examined by the is the same one or not.
I have not found anything from.
So what do you submit? That benefit will go to the petitioner.
Submission may be recorded. my-
But Mr. Mishra, you have not taken this point. You have not taken this point. Mr. Bora,
Yes, ma'am, it was not there, ma'am.
one assistance. This is a case of recovery of opium. Be that how it was recovered from the tea garden of the petitioner. Be that as it may, it was recovered. 100 grams were estimated. Out of that, 2 packets of 5 grams were made for sending to the FSL. The learned trial court has found that the measurement was not proper. Be that as it may, he said this is not a commercial quantity, it's a lower quantity. So a punishment was given of 6 months imprisonment. Now, when I was going through the records, I find that the FSL report, no FSL authority was, forensic expert was examined, but the report was exhibited by the IO. In the report, it is written that the quantity received is 1.5 grams. That is damaging.
The damage that the contradictions.
Contradiction because that benefit will have to go. Just see that statement
1.5 gram, yes, well.
and see the statement of PW1. On this point,
But what it says is a approximate, onumanik.
Hmm.
Approximate. It's what it says, not 5 grams. It'll about
but there
5
are 2
grams.
packets,
Yes, sir. 2 packets of
5 grams,
It's not that 5 grams, about 5 grams.
about 5 grams.
About 5 grams.
But there
There
it says,
we found 1.5.
so what
So-
this inconsistency is not explained.
Yes, my lord, but whether, my lord, this work can it 100 gram বুলিও অনুমানত কৈছো
Hmm.
that it was not be measured, it is on approximately
100 grams.
so it is a major contradictions, my lord. Major case of 1.5 and 5 grams
2
অনুমানিক,
packets.
2 packets that cannot
No
be.
explanation.
There's no explanation to that, so definitely benefit goes in favor of the accused, my lord.
But the accused has not taken that point. It has come to the notice of the court. We can always take that issue.
Yes, my lord, definitely, definitely. Whether 313, my lord, whether
No, nothing. Nowhere this issue was taken up.
no question has been put
No.
on 313,
No.
then your lordship may take it.
On the examination, we found.
Yes, yes, examination of. Then is no point has been even 313 or others also. No, this is definitely.
But that is a
is
material
major contradiction.
major contradiction.
It's not a minor, it's a major contradictions. Getting 1.5 and 5 web so and so, and what it says 100 grams also Anumanik.
Anumanik, that's fine.
Anumanik.
That for that the learned
5
trial
grams
court.
is Anumanik also.
Anumanik. So 5 grams is also
But in the
Anumanik.
report, it says specifically
1.5 grams. So whether this is the same material that was sent
Then
and which
definitely.
was, that is not.
That is not there either in a evidence
Or in.
or in even 313 also no question has been put also.
So we can take that and
Fine.
dispose. Second half, 2 o'clock. we'll pass the notice. মুখ খালি record room or TD whatever.
Again, here or not this.
No. 2 o'clock we'll pass the order. We are quashing the sentencing.
My submission may be recorded only.
Yes, what? Okay, when I'm dictating, you give me, I'll record it. But this is a major contradiction because you see 5 grams, Anumanik.
It is also the duty of the trial court, my lord, to call the FSL authority, my lord.
That you next time you go and tell them. There. 40 to give. None appears for the petitioner on call. Yes, any volunteer? Amicus curiae? No, criminal matter. Let's see somebody. I like no idea. Mr. Nawaz. But this is you have a better one. Some younger counsel here. Yes. What happened? Anybody? Like Mr. Das, Mr. Mahajan. You are here in this case. Sudam Das, no. Huh? A copy at a Didiba. Sudam Chandra Das. Huh? Day after. Mr. M.
N Mahajan.
N. Mahajan. None appears to Lihisana. Is appointed as the amicus curiae in this matter. Courtmaster to furnish a copy of the appeal memo along with its enclosures during the course of the day to Mr. N. Mahajan. The registry to list this matter again on Thursday, showing the name of Mr. N. Mahajan as the amicus curiae in the matter. So, Roy, what is the error?
My lord, the appellate court, lordship has seen both the judgments, my lord. Appellate court judgment is a very cryptic one. It did not, my lord, give any reasons to disagree with the finding of the trial court. None at all. The learned trial court's judgment is, my lord, a detailed judgment, your lordship. I'll read the relevant part of the trial court judgment, and lordship, how appellate court has dealt with it, lordship. I'll go into it, my first, my lord.
Your case is that the conclusions of the appellate court is one that
He did not follow.
did not follow.
How can he follow? He's a chowkidar. He must be there. His duty is to remain there and look into it, you know. This is a, my lord,
Who is appearing for the respondents?
Time being, Lordship.
Who is appearing for the respondents?
SK Ghosh.
Two, 3-page judgment, my lord, the appellate court judgment. And the trial court has gone into every aspect of the matter.
How long will it take?
half an hour. Lordship,
No, to be a fixed much. After some time, Mr.
Course.
Yes. Injury to the mother.
Yes, my lord.
Hmm.
Well, page 21, what will come to, my lord?
Hmm.
Like, my lord, it's a fight between the family members, my lord. Factor in the head, my lord.
Hmm.
PW 1 is the sister, 2 is the brother, and 3 and 4 independent, my lord. They saw the injury, my lord.
They saw the injury, not the
Not the
incident.
fight.
They are not eyewitnesses.
Eyewitness. PW 2, 1 and 2 saw the occurrence.
Hmm.
Is there, my lord. She herself
Hmm.
has hit her, my lord.
Hmm.
Jurisdiction, my
Hmm. Very limited.
yes, my lord. Thing is, my lord, the appellate court, my lord.
Hmm.
It will come to my lord. My lord.
Hmm.
There's no consideration to release the accused. Be considered, my lord. Be considered, and if it is to be rejected, my lord, special incident was in the year 2007, my lord. That time, my lord, the accused was around 28 years of age, my lord.
No, what is the error?
The error is that, my lord, the appellate court, my lord, did not consider. Has to be done, my lord. First time offender, my lord. At the grave allegation, my lord. Family, my lord.
Mother.
Mother, my lord. And now, since, my lord, 2013, the else has come up, my lord.
So it's only to that extent.
Yes, my lord. I'd like to order, my lord. Lordship, will kindly see, my lord, paragraph 20, my lord. '21 and 22, my lord. Has to be done, my lord. Rejected, my lord, then special. This entire proceedings for the past 18 years, my lord.
Mother is alive?
Other, from my evidence, she was 50, my lord, at that point of time. Now she's around.
Yes, Mr. Chutia.
Paragraph 10 of the appellate judgment, my lord.
Hmm.
In the after evaluation of all the evidence, my lord, the imposing punishment. Regarding the provision of Offenders Act, that plea that there is any plea before the trial court on that, my lord. There is no plea on the trial court before the, my lord, trial court as well the appellate court about release of the at this point of time after the judgment.
No, this plea can be taken in an appellate court also. There is no bar in that.
My lord, but there is nothing in the, my lord, record that there is a plea.
No, considering the nature of the grievance,
My lord.
and it being basically a dispute between the family, not having an effect with the public at large.
My lord.
And yes, he has attacked his mother, but what was the thing? And now I think this case is of, the incident is of
Incident is
2007. 2007.
7, my lord.
Yes.
So now we are 18 years
My lord.
gone by. We'll give him that. Second of ODD one. If possible, today itself we'll pass it.
Obliged, highly obliged.
A BNS to diversion. Yes, Mr. Suikya. Their statements were not recorded
My lord, not recorded any,
Sure.
my lord. My lord,
because this case is received on transfer for disposal.
my lord, my lord.
Whether the earlier court had recorded this statement.
No, my lord, not recorded. I have especially mentioned and my annexed the order sheet also, my lord. That is
No, order sheet is
And-
only one, page
one, my lord,
30.
one. Not recorded, my lord.
No,
This-
30, page 30.
My lord, my
You
lord.
have said in your petition not recorded.
Yes, my lord. And my lord, the ingredient also not present, my lord. Against the present petitioner. accused number-
Ingredient is something different.
My lord,
But
my
whether the procedure has.
No, my lord. Yes, my lord.
Yes, Mr. Burwa. No, just, it seems that the procedure under 223 has not been followed. A statement has to be, evidence has to be taken of the complainant before issuing notice. Huh? That is mandatory. His content will only have to examine that. So we can call for the case records, scan copy and issue a notice. When is the next date fixed? But Mr. S. Soikia, Learned Counsel for the petitioner. The present criminal petition has been instituted. Assailing. A notice dated 6/5/20, an order dated 6/5/2025, passed by the learned Additional Chief Judicial Magistrate, Gulaghar, in CR case number 58/2025, issuing notices to the petitioner herein. Full stop. The above noted CR case number 58/2025 was registered under section 318 bracketed 4 of the BNS 2023. The Learned Counsel for the petitioner categorically submits that before issuance of the said notice, said order dated 6/5/2025, requiring issuance of notice upon the petitioner hearing, the learned trial court had not recorded the evidences of the BNSS BNS of the complainant. Also, it is submitted by the Learned Counsel for the petitioner that the procedure as prescribed under section 223 of the BNSS has been violated by has not been complied by the learned trial court before directing for issuance of notice upon the petitioner herein, who is the respondent who is the opposite party in the said complaint case. Also, in view of the said submission made by the Learned Counsel for the petitioner, this court is of the considered view that the matter would require an examination. Also, issue notice returnable 4 weeks. Petitioner to take steps for service of notice upon the sole respondent by way of registered post with ID, steps within 2 working days from today. Also, considering the submissions made by the Learned Counsel for the petitioner and as noticed herein above, further it is directed that till the next returnable day, further proceedings in CR case number 58/2025 shall remain suspended. Yes, Mr. Barua. What is the stage of the investigation and whether it has been found that the vehicle is involved?
That is, my lord, lordship will find from the FIR itself, my lord. FIR, my lord, also he has not annexed the, my lord, Caesar memo, my lord. Page number 23, lordship may kindly see. Number 23, above, my lord, serial number 4, my lord. That is the, my lord, one Pulsar, Bajaj Pulsar bike, my lord.
That was recovered
Oh.
from the site, please.
Yes, madam. Now, my lord, this application was rejected Zimma on 18/3/2025, my lord. What is the status of the investigation, my lord? That we have.
You take your instructions. Take a report. Considering the nature of the issue arising in the present proceedings, and the order under challenge being passed on 18/3/2025, this on the ground rejecting the prayer of the petitioner herein for Jimma of the motorcycle of his on the ground that the investigation in the case was under process, was in progress, this court requires Mr. R.J. Barua, learned additional public prosecutor appearing for the state to obtain a status report from the investigating officer of
South Salma PS case number
South
210.
Salmara PS case number
210.
no, Mankachar PS case number 219/2024.
South Salmara.
South Salmara.
South Salmara. But IO is from the Kharuavanda OP.
You come to your cause title. South Salmara PS case number 210/2024 under section 22 bracketed A /22 bracketed C NDPS Act. Registry to list this matter. How long will it take? Registry to list this matter again on. No. 24/9/2025. I am dead.
Lordship, hearing counsel is in different courtroom.
After the, we don't know. There was an order passed yesterday.
Similar order मैंने pass किया.
Yeah. Same case, same thing. Same order.
Along with the
Tech Quediba. The registry to list this matter again after 4 weeks on a date to be fixed by it, along with criminal petition number 1096/2025.
places.
Hey, Sabha. 17 years, 5 months. Yes, what do you say?
Look, as per the FIR, my lord, admittedly she was R164 by my lord. Herself says, my lord, what is her date of birth? But 23, my lord.
What is her name?
Name is my lord Tara Shettar, my lord. Elias.
She is a petitioner here.
Also
Number
petitioner, my lord.
three petition.
But accused person, his father and the my lord big.
I know that. No.
Was minor at the time of his. Now, my lord, she got married, got to a child, my lord.
Going by the recent order, my lord, 2025, line 614, my lord, where it is held at my lord.
Copy. Maybe, we'll see. Because, yeah, okay,
My lord,
few
what-
months.
My lord,
And now that marriage is there, the girl is also before us as a petitioner.
And also, my lord.
She said, she says that she is a major on that day. So, okay, we'll consider. Heard Mr.
J. Lashkar.
J. Loskar, Learned Counsel for the petitioner. Also heard Mr. R.J. Barua, Learned Counsel appearing for the additional public prosecutor appearing for the state respondents. Considering the nature of the issue, considering the issue arising in the present criminal petition, this court is of the considered view that the same would now be required to be heard and disposed of expeditiously. Accordingly, the registry is directed to list this matter again on 22/9/2024. Huh? Upot ata likhi diba, issue notice returnable 22/9/2025. 22/9/2025. Huh? Full stop. Till the next date of listing. Further proceedings in special POSCO case number 12/2023 pending before the Court of the Learned Special Judge Dima Hasav Hamplong shall further proceedings shall remain suspended. 22/9.
22/9.
Lordship, I'm on behalf of Mr. Irafik. May I please, Your Lordship, kindly pass over the matter for the day. As messenger.
As prayed for by the Learned Counsel for the petitioner, registry to list this matter after 2 weeks on a date to be fixed by.
Challenged, my lord, the author of cognizance, my lord. Court below has taken cognizance, my lord, in violation of the provisions of section 39. My lord, section,
Where is that provision of section 39?
my lord, I am
Yep.
giving you. Note section 39. We read, my lord. Cognizance shall be taken of any of or with previous sanction in writing of the chief inspector and no inferior court to that of a presidency minister. My lord, the previous sanction of chief inspector is missing, my lord, and I have been relying on a similar case, my lord, wherein
Court shall take cognizance of any offence under this act except on a complaint made by
my lord,
the chief inspector, or with the previous sanction in writing of the chief inspector.
yes, with a similar order, my lord, I am placing reliance. Lord,
Who has filed where is the complaint?
the complaint, my lord, is at page
Labor inspector.
inspector. P7 and the complaint, my lord, the reading of the complaint, nowhere it has been, my lord, stated that the previous sanction is taken. There is no averment in the complaint.
The complaint can be made directly by the chief inspector. Who will be the chief inspector here? It
Yeah.
would be the labor inspector, the labor commissioner. Who is the chief inspector in the state? In the state, who is the chief inspector?
But I also exactly cannot say, my lord, but the person who has issued, he is not the chief inspector, my lord. There is only one chief inspector, chief
State.
entire state. But them, the labor inspectors are there. Complaint is at page, my lord, 27. That's from 26, annexure 3, my lord. 27. My complaint is there. Impugn order of cognizance, my lord, is at page 29 and 4. 39, my lord, which mandates the sanction in writing.
Heard Mr. H. Gupta, learned counsel for the petitioner. Okay. CR case to board level. What is the CR case number?
My lord, is 256 of
56, huh? 56 of, yeah, 256
56.
of 2025. Presently pending before the, yet I say, 1, 2. Managing Director of, what is the Manabari? Same thing.
Manabari Tea State.
5, 6, 7, 8, 9. Yeah, from idea. Registry to list this matter again. Registry to list this matter along with criminal petition number 832/2025. It yet issue notice to us, we should last totally. After 4 weeks, along with WPC number, criminal petition number 832/2025.
I've been forced to venture into unknown territory. You'll
No,
kindly
that you don't worry. This court is also in a sea.
And, we filed a petition for discharge that has been rejected. But if your lordship will first come to page 23, that's the in fact, page 23 is the FIR. If you're relevant.
You had tried to, the allegation is you had tried to snatch a gun.
Yes.
But at that point time you were not identified. But subsequently,
Never identified.
subsequently they say, where is the,
That is the issue, man. If your lordship will just allow me to.
unknown person. The FIR was unknown person.
FIR was unknown person and it remained unknown throughout, my lord. If your lordship will kindly come to page 51, the statements are recorded from page 51 onwards. This is the informant himself. Page 51. He maintains that it was an unknown person and last sentence makes the position clear. Later on, I came to know from the local people that the name of the said person is Hitesh Halwe.
Bas.
He comes to know from someone else. Now, rest of the statements, your lordship will kindly see, page 52. This is another person whose statement was recorded. My name is so-and-so, he is the head clerk. And thereafter, my lord, somewhere in the middle, towards the right, at around 1 a.m. at night, while we were on duty, we've seen that an unknown person tried to snatch away the pistol of Paresh sir. Immediately, we have tried to apprehend the person, but he had already fled away from there. So he also maintains that it is unknown. Then your lordship kindly turns to page 54, another statement recorded. Page 54, your lordship will find that this person was having dinner somewhere else. So there's absolutely nothing to connect me. Page 54 and 55, your lordship will find that these two were having dinner somewhere else. And the other statements are at page 57. These people say that we came to know next day. So there's absolutely no material to even remotely connect me.
Then how were you connected? What was the material?
The only material was someone told him that the person's name is Hitesh Halwe.
And what did the trial court, when
Your
you...
lordship, that is what is the interesting part. If your lordship will kindly come to page 81. That's where
that is by the trial court, 81.
81 it starts. The relevant portion, your lordship will find from page 87. I have meticulously perused the materials available in the case diary, case record, etc., etc. I have also gone through the written FIR and the investigation form. Though the petitioner pointed out the contradiction, it needs to be mentioned that the petitioner himself in his petition in para number 2 stated that as per the FIR laws, the informant on so-and-so, along with his staff, proceeded for performing their duties at so-and-so. From this, it is apparent that it is well within the knowledge of the petitioner that the date is not 23/5, but rather it is correctly mentioned in the written FIR as 13/5. Hence, I find no discrepancy. This is with regard to the date which you are not really concerned. Further perusal of the FIR reveals that on 13/5/23, the informant Paresh Das, along with his staff, namely so-and-so, went to discharge their duties at so-and-so. The informant, while discharging his duty at about 1 a.m., an unknown person tried to snatch away his service 9mm pistol. But as the lanyard was attached with the pistol, the person could not snatch away the pistol. The informant, knowing the same, immediately tried to apprehend him. But the said person, taking advantage of the huge crowd at the place of occurrence, pushed the informant and fled away. On inquiry, the informant learned that the name of the said person is so-and-so. This is the only way I was connected. However, and most importantly, my lord, that the sections, if your lordship should have a look at the sections, well, 393, 323, and 353. Your lordship will have a look. These are not even remotely attractive.
No, we got it.
There has to be some cogent material to connect me to the crime.
But Mr. Chaudhary, while we consider a charge sheet per se, clear may have.
That
Must
is
have
why
is not required.
That is why the Supreme Court says that there has to be a distinction between suspicion and grave suspicion. Your lordship has a look at any of the judgments. Rajan Kumar Kadus. Or rather, let me place a recent judgment. 2019.
Neharika. What was that? Neharika? No.
2019. 2019 is.
There is a judgment of 2000 after COVID, 23.
This is that Deepak Bhai Jagdish Chandra Hotel. This is one of the recent ones.
Yes, Mr. Borwa.
Kindly come to the FIR, my lord, page number 33, my lord. In the vernacular, my lord, I am not reading the entire portion, my lord.
Just a moment.
So down, little down below, my lord. Salar Prajan Osinakto Lorai Moore Service 9mm pistol to Karilo Jabo Bisorat, pistol to Logai Toka Rusi Dollar Babe Nibu Nuarile. Logalegam Gompa or Lorato Tapmai Doru, my lord. Jodio Utsov Stoli, Donata Vidor Huzug Loy, Muk Telamari Lorato Polaize. আৰু স্থানীয় লোকৰ পৰা জানিব পাৰো যে ল'ৰাটোৰ নাম হিতেশ হালৈ son of so-and-so, my lord. I took not the accused person, my lord, but he fled away, my lord. Then
See,
immediately,
this
my lord,
FIR is of 13/5.
3-5, my lord.
No. 13/5.
13-5, my lord, yes.
Come to the next page. And the incident is also of 13/5. Mr. Chaudhary, this will require some examination.
And lordship may kindly see in the search sheet, my lord.
Except that hearsay portion, that some local people said that, there is nothing else to connect me.
No, that information he has reduced it in writing. Now the charge sheet is filed. The court you have a opportunity there.
It's a matter of trial, my lord.
Trial.
You have to prove, my lord, that he was not the person.
There has to be some material. It cannot be a case of mere suspicion.
And the district judge has also, the session judge has also examined the matter.
My lord, but what has been recorded? There's absolutely, even in that order, your lordship will find.
Your projection initially was that the FIR is of 23/5.
That I am not even on.
It's of 13/5 itself.
13/5.
And the name of the accused is disclosed therein.
Name of the accused disclosed how? Because some local people say.
That's an information. Whether that is correct or not, that is a question of trial.
But except that hearsay, is there any other material to connect me? That is the question. If they proceed merely on this basis, it's a pure case, my lord, where merely on the basis of some suspicion, a case which trial will
When is the next date?
today, my lord, in fact. Lordship will examine the matter.
No, we are
Then
not,
early date.
we will fix an early date for the final disposal of this matter, but interim we are not considering. Heard Mr. I. Chaudhary, Lana Senior Counsel, assisted by Mr. A. Chaudhary, Lana Counsel for the petition, and Mr. R.J. Borua, Lana Counsel for appearing for the additional public prosecutor appearing for the state. Full stop. Issue notice. Returnable 2 weeks. Mr. R.J. Borua, Learned Additional Public Prosecutor, accepts notice on behalf of respondent number 1. Petitioner to take steps for service of notice upon respondent number 2 through the office of the Public Prosecutor, Guwahati High Court. Also, the office of the Public Prosecutor shall effect the service of notice upon the respondent number 2 through the officer in charge of the police station wherein he is currently posted. Full stop. Considering the nature of the issue raised in the present proceedings, this court is of the considered view that the same would mandate an early consideration. Accordingly, registry is directed to list this matter again on 23/9/2024.
That entire week I'll be in
19?
19.
19/9/2025 for admissions. An endeavor would be made to dispose of the matter on the next date of listing.
Till then, my lord, because if
I
the
think
charge
this-
is framed, if
no,
the
no.
charge is framed,
This what we have given you is enough for the lower court to give you a date. Yes. Okay, I may be wrong. We'll try.
right.
Very busy, Lordship.
Hmm.
Lordship, application filed under section 528 BNSS, Lordship. We have challenged the Lordship charge sheet as well as Lordship the
Oh, that railway matter.
cognizance and the proceeding of the PRC case pending before the court below. Lordship. The sections are involved under 120B, 406, 420, 460, 470, 71 of the IPC.
Cognizance taken?
Taken, Lordship. Lordship, there are 6 persons charged in the Lordship case.
What is your ground?
Ground Lordship is that Lordship, my name is nowhere in the FIR as well as Lordship. A single line is.
But the charge sheet brings materials against you.
Charge sheet, Lordship may kindly see for a moment.
You are?
Page number. Niranjan Sutradhar, Lordship.
Niranjan Sutradhar.
Yeah, advocate by profession, Lordship. Page,
Oh.
page number 30, Lordship may kindly see. Page number 29.
Hmm.
Paragraph 16, brief facts of the case. Starts. Then Lordship, during the course of investigation, the following actions have been taken. Then Lordship may kindly come to page number 30. Last part is started with bold letter Lordship word. Interestingly, when the Lordship certified copy of the power of attorney is constituted between the complainant Junu Bawel and the accused person Uma Shankar De Sarkar has been collected from the office of the town development authorities, it is noticed that the said power of attorney bearing CLM so-and-so prepared and dated so-and-so was drafted by the advocate Suman Sur. He is also one of the accused here, Lordship. Whereas the same power of attorney collected by the complainant through RTI from office of the DC, the revenue branch, which has been.
So the power of attorney which is forged.
Yes, alleged to be forged.
Alleged to be forged. That was name of Sur.
Suman Sur.
Suman Sur. Now the evidence says that this was prepared by you.
No, Lordship, that I am coming, Lordship.
Hmm.
Then Lordship may kindly skip that part. During the course of investigation, Lordship has got it.
Hmm.
The accused persons reveal the name of the alleged person Sri Niranjan Sutradhar, the petitioner here in Lordship. Advocate who has worked with for them. In this case, also the alleged accused person is involved as the fake power of attorney was actually drafted by him, but signed by junior advocate Snigdha Chakraborty. So he has neither drafted it nor identified any of the parties. That has been done by the junior Snigdha Chakraborty. And this petitioner being
You did not, but you may have been the master who had done it. Got it signed by your junior.
Junior is a Lordship defined identity, Lordship. So for junior action, lordship, the senior that the petitioner cannot be the lordship prosecuted lordship. And this is the also the version of the accused persons. No witnesses have stated anything, lordship.
That will come out in the trial.
Lordship, that lordship may kindly examine lordship, notice number 2 lordship. This is the only thing, lordship. Nothing mentioned in the entire charge sheet, lordship.
Juno Bowal is the informant.
Inform. Is a very long FIR, lordship.
Yes, Mr. Borwa.
Notice, my lord. Notice
That
and my
much.
lord, scan copy may be called for, my lord.
Scan copy along with the case diary. Kindly consider that lordship prayer.
Not in such nature of cases. We'll have to be very careful. Also, heard Mr. N. Hassan, learned counsel for the petitioner, also heard Mr. R.J. Borwa, learned additional public prosecutor. Also, the present criminal petition has been instituted, presenting a challenge to the charge sheet being charge sheet number 88/2025, laid by the investigating officer of what is that case number?
PS case number
It is
542
of Tinsukia PS case number
542/2023.
2023, corresponding to the case there, PRC case number
PRC case number.
270/2025, presently pending disposal before the Court of the Learned Special Judicial Magistrate, Railway, First Class, Tinsukia. Also, issue notice, returnable weeks. Mr. R.J. Borwa, learned additional public prosecutor, accepts notice on behalf of respondent number 1. Petitioner to take steps for issuance of notice upon the respondent number 2 by way of registered post with AD, steps within 2 working days from today. Also, registry to call for the charge sheet is here.
As it is there, scan copy of the TCI along with the case there.
Any development, any evidences recorded?
No. Only the state of appearance.
This will do.
Some of the statement of the witness.
161. But that will not be a part here, the charge sheet. Okay, that investigation, that statements have not been enclosed. Okay, registry to requisition, registry to requisition.
Report, my lord, regarding my lord,
record scan copy of the trial court records. Also, registry to list this matter along with the scan copy of the trial court records on the next date of listing.
Along with the case date.
That statements will be there. That will do.
They do not, that doesn't come with the TCI. Sometimes.
When you challenge, what is the requirement of a case diary? It's the charge sheet and the materials there. And the statements will be there. You'll see.
4 weeks, man.
4 weeks.
Obliged.
Why is it listed before this court?
Your lordship is, the matter has been heard by your lordship. No, your lordship is heard the matter. It's regarding the cattle market.
No, I got it. I got case to some. I
Yes.
think we had,
Market,
because this matter was filed, so we required this matter to be heard.
my lord, because Anshalik Panchayat, my lord, was not before your lordship. Earlier the
further hearing.
No, it's not there. It's not for further hearing. It was for further hearing when we were considering whether Madam
yes, my lord,
Goyal
on
had a locus or
my
not.
lord, on locus of my lord, that question has been arises, my lord.
Hmm.
On that day I appeared, my lord, and I filed this writ petition, my lord.
Hmm.
I have a copy has been supplied to your lordship. On going through, my lord, your lordship has a direction to list the matter before your lordship along with this matter at the motion stage, my lord.
Hmm.
The question before your lordship was regarding that which market they will run either on a Friday and Wednesday, my lord. These are the, my lord, issue before your lordship. Now, if your lordship kindly see,
No, Mr. Bora, the only issue is that this is not the court taking up this roster.
my lord,
And I don't find that I have kept it to myself.
my lord. No, your lordship has, I don't know, but your lordship has given a direction to the registry
To
that
list
be
it
listed.
when the motion is listed before the appropriate court. How can it come back to me
I don't know, my
It
lord.
was there as for further hearing, Lord.
earlier? I think it should go before the appropriate court.
My lord,
Because that interim order is already there.
same order is there, my lord.
And we did not dismiss that because if we do that, it will affect the
My lord,
the panchayat, so we kept it.
my lord.
So, this matter has been listed before this court along with WPC number 3389/2025 and WPC number 237 of 2025 to 5157 of Lihiva. So, this court in WPC number 3389/2025 and WPC number 237/2025 had wide order dated 28/8/2025 required the said writ petitions to be listed along with the present writ petition when the same is listed for motion. However, the said case was not kept tied up with the present bench. Also, as the present bench is now assigned with the criminal matters, registry is required to list the present writ petition along with WPC number 3389/2025 and WPC number 237/2025 before the appropriate bench, taking up appropriate bench. Full stop. The matter be not treated as tied up and or tied up matter with this bench any further. Full stop. The interim order passed on 18/6/2025 in WPC number 3389/2025 shall stand extended till the next date of listing of the present writ petitions. Full stop. Registry to list this matter. Full stop. As prayed for by the learned counsel for the parties, registry to list this matter Thursday. On Thursday or Monday.
Let it be Thursday, my lord.
Subject to consensus.
Yeah, so,
Monday on 15/9/2025 before the appropriate bench. It will not be proper. Anyway, you are protected otherwise also.
47.
That is a lodge.
Hmm.
Sorry, Lord, with the data.
No, it's okay, Mr.
The present petitioner is agreed by order dated 17/7/2025. Passed by the learned additional sessions Judge Hosai, whereby the said learned court set aside the order dated 9/10/2023 passed by the learned chief judicial magistrate, the order of discharge. Actually, what happened, my lord, the respondent number 2 herein as a complainant filed a complaint petition before the court of learned chief judicial magistrate.
What is the error in the order of the learned?
Absolutely civil nature, lordship. Absolutely. For a moment, if your lordship sees the evidence of the PW1, evidence before charge, for a moment, if your lordship may peruse it, lordship will find that what relief she is sought for. Page number 23 is the vernacular.
A statement is also to the effect that also.
The lordship, the complaint petition, the evidence, everything is civil nature. She is claiming the land only, nothing else. Therefore, the learned chief judicial magistrate rightly observed that it's a civil nature dispute between the parties. So parties maybe go for a civil court, and therefore
Now she has been directed to adduce further evidence. Now, if you see her statement
lordship may complete for
at
page number
page
23.
Fulmai Devi.
Yes, page number 23. It's vernacular. May I read, lordship? Page number 23. মই গোচৰণী গোচৰটো উপস্থিত আছামী পুতুল নাথৰ ওপৰত দিছো
ৰাণী নহয় য়ানি গোচৰটো
গোচৰ য়ানি
উপস্থিত আসামি পুতুল
মই আজি
নাথক
ঘটনাটোৰ দিন
মই
আজি
আজি
ঘটনা দিনবাৰ পাহৰিছো। মোৰ স্বামীৰ নামত জামুমণ্ডলত থকা চাৰে 3.5 মাটি 12,000 টকাৰ বিনিময়ত আসামী পুতুল নাথক বন্ধকত দিছিলো আৰু উক্ত টকা পৰিশোধ কৰি বন্ধকী মাটি মোকলাম বুলি কৈছিলো। কিন্তু পৰৱৰ্তী সময়ত মই আসামীৰ পৰা লোৱা উক্ত টকা ঘূৰাবলৈ যাওঁ, কিন্তু আসামীয়ে উক্ত টকা ঘূৰাই নলয় আৰু মোৰ লগত তৰ্কাতৰ্কি কৰে। তেতিয়া উপায়হীন
মোৰ
হৈ
প্ৰাপ্য
মই
মাটি।
প্ৰাপ্য মাটি আসামীৰ পৰা ঘূৰাই পাবলৈ আদালতত গোচৰ দিছো। ৰিলিফ
গোচৰ কৰো
গোচৰ কৰো। মই মোৰ সম্পত্তি আসামীৰ পৰা ঘূৰাই বিচাৰো। মই উক্ত মাটি প্ৰায় 25 বছৰ ধৰি ভোগ দখল কৰি আছিলো। আসামীক বহুবাৰ অনুৰোধ কৰা স্বত্বেও তেওঁ মোক
There is a title suit also pending.
Oh.
No title suit now.
Is it-
Yes,
Party appear, my lord.
that's it. Till that time we are staying it. But Mr. P.P. Borthakur, learned counsel for the petition, also heard Mr. R.J. Burwa, learned counsel appearing for the learned additional public prosecutor appearing for the state respondents. Issue notice returnable 4 weeks. Mr. R.J. Burwa accepts notice on behalf of the respondent number 1. Petitioner to take steps for service of notice upon the respondent number 2 by way of registered post with AD. Steps within 2 working days from today. Also, considering the order, also, the learned counsel for the petitioner has prayed for an interim direction. Also, accordingly, this court has perused the order passed by the learned trial court as well as the order passed by the revisional court. Also, on a perusal of the materials brought on record by in the present petition, this court is of the considered view that the petitioner has made out a prima facie case for being granted an interim direction in the matter. Accordingly, the order dated 17/7/2025 passed by the additional district and session judge Hussain in criminal revision number 11 of 2023 shall remain suspended till the next date of listing of the present criminal petition. Full stop. The registry to list this matter after 4 weeks on a date to be fixed by. Mr. Monto, I think we will take this matter after some time because now it's criminal.
My lord.
You had a matter, Mr. Singh is appearing, but you know, I think he is not so we have appointed an amicus curiae in the matter. Mr. Singh has not briefed you, I suppose, in the matter.
No, my lord.
As agreed to by the, we'll have it immediately on reopening.
My lord.
As agreed to by the learned counsel for the parties, registry to list this matter again on 15/10/2025 for further hearing. 57, huh? Yeah, material. Yes. What is to be done today? Yes, Mr. Das, after a long time.
I think.
What is to be done here? Is it to be taken up for disposal today?
I'll leave it before my friend, my lord.
Then we'll have it after immediately on reopening. As agreed to by the learned counsel for the parties, registry.
Can I make a prayer, lordship? Difficulty, can it?
Give me a date.
Last week of November, lordship.
No. What about the last week of October?
Yes.
As agreed to by the learned counsel for the parties, registry to list this matter again on 28/10/2024 for admissions.
23rd, my lord.
23rd. Okay, done. 23rd. 23. 23.
There is an interim order, my lord.
Interim order passed earlier to continue till the next date of listing. When Mr. Das asks, we'll have to give. Mr. Chaudhary, you have some matter? 6-0. Second half after the thing.
Fine.
Who are you? Look, top of the list matter ne?
Motion.
Top of the list.
Top of the list. Oh, two. Motion no hai. Top of the list. Okay, that matter. You have your instructions. We are not adjourning this. And tell us how the order of the trial court you are supporting.
Trial court.
Oh, sorry, appellate court.
This is a appeal, my lord. File this appeal. I have filed this appeal against conviction order.
Order. They have taken special leave and they have filed this
Filed
appeal.
this.
So you have to justify the appellate order, basically.
Appellate order passed by the learned district.
Oh. That is what you have to support.
My lord, here in this case, learned trial court has not considered the vital aspect of the matter.
And
that-
tell me one thing. What is this reasoning that the person,
that is I am.
he has to go and look where the thing is stolen is taken?
No.
But
Question of stolen. Initially, the case was filed before the.
You have your instruction who is passed away and that will
FIR was lost. Then final report was submitted. It is in the final report, it has come that he has purchased land of the school property. Fraudulently obtained a sale deed of the school property.
That is not the issue here.
That is the issue. That is was.
Okay, we'll take it
that
up.
was considered by
That was at first item.
Sessions,
2 o'clock first item, you get your instruction who is there, who is not there.
Sessions Court has considered.
You come, we'll see, 2 o'clock.
And in the final report also, it was there, my lord.
2 o'clock. 2 o'clock, I'm not hearing it, 2 o'clock. You just get your instruction who is alive, who is not there now.
That actually.
2 o'clock. No adjournment.
No, I am not praying for adjournment.
That's why you get that instruction, or we'll proceed that all are alive. We'll proceed under with the belief that all are alive. Right. So against one it'll a bit, but the others would be there.
But there must be some order passed by that.
Pass it together.
Then, my lord.
Because there are two others.
Three others.
Three others.
Yes.
So
Kindly see, my lord.
let Mr.
W1 kindly see.
Let Mr. Roy make his submissions. We'll come back to you later. Mr. Chaudhary, that matter may take some time. Is it very urgent or you can have it?
Come up on Tuesday.
Tuesday. Because I'll have to finish the old matters. Old matters I'll have to. Item number? 660. Cause list good.
The state was supposed to give a state.
Yes. Yes. You have a status report, sir. Mr. Roy, we'll just have this matter and come. You are for the respondent.
For the petitioner, my lord.
Okay.
I was a bank officer. Certain loans were.
Amlan Jyoti Bhuya.
Lord, yes. And my lord, most of the, none of the accounts are NPA. Everything is going on smoothly, my lord.
Yes, Mr. Goswami. Mr. Borua, you're supposed to get a report, status report.
My lord. On several occasions, they have taken time, my lord.
Mr. Goswami was supposed to get the...
On different occasions, my lord, different APP appeared.
BIO...
BIO case.
BIO case. Mr. Goswami, Mr. Chaudhary, we'll have it, fix it on Tuesday. We'll have the status report by then. Mr. Goswami, ask Mr. Goswami to just come.
Pilot, he's coming then.
You can leave, you need not, your junior should be.
Deeply.
Yes, Mr. Roy.
My lord, will have a look at the appellate order, my lord, at page 20.
Now let us go to the root of it.
Lordship.
The
Trial court, my lord.
trial court order.
Trial court, my lord, is at page 11.
GR case number 120, 2010. Yes.
My lord, should I read the entire, my lord?
No, just give me the.
Lordship will, I'll give the page 13 is the decisions.
Evidence.
Discussions and everything. I'll just read that part, my lord.
Mm.
PW1, Vijay Krishna Das, the complainant inter alia testified that he is having a plot of land nearby E, A and D colony, wherein a watchman, namely Dhananjay Das, resides with his family. According to PW1 on 7/2/2088, at about 2 a.m. and to 3 a.m., the said watchman Dhananjay Das informed him over telephone that some persons have committed theft of 5 quintal of rod as well as 30 bags of cement. PW1 further stated that he has telephoned Shushanto Shyam, his relative, and proceeded to place of occurrence, wherein he has met with the said Shushanto Shyam, Dhananjay Das, and his family members and others, other people. PW1 furthermore deposed that Dhananjay Das informed him that the accused persons, Debangshu Chakraborty, Piklu Chando, Orup Roy, Bikash, and others have removed 5 quintal of rod and 30 bags of cement from his land, threatening Dhananjay Das with dagger, asking him not to raise alarm. PW1 again testified that the accused persons have removed said materials by handcart. In cross-examination, PW1 inter alia stated that title suit number 14 of 2010 pending in the Court of London Munsif, he has submitted written statement as defendant number 7 on 5/3/2010, and in the said written statement, he has not cited about the existence of the said house watchman as well as theft as alleged in his case. PW2 Dhananjay Das.
This case, this title suit was instituted by the accused.
Perhaps, my lord. Then, request. Next, my lord, this is
On land, which was with
Not this property.
not this, my lord.
his property.
Same property.
Same property, school's property.
No,
we
no.
have,
Say this
executed
property
a
belongs to
sale deed.
the complainant, not
School's
this property.
Executed sale deed.
Which is, okay, there is a title
That
suit.
was
Okay, fine.
subject And second
Yes.
appeal is pending before this honorable court.
PW.
Second appeal. By whom?
By the,
The decree, suit
by-
was
by the-
decreed against you.
no, we have filed this suit. Suit
Ah.
was dismissed.
Then appeal.
Then appeal, then second
Appeal also dismissed.
that.
Appeal will be dismissed. That's why you have
that's
filed
why
the second appeal.
Second appeal.
Okay, fine.
Now, my lord, this is relevant. PW2 is the eyewitness. Dhananjay Das inter alia deposed that he was engaged as a watchman by the complainant during this fateful night. At about 2:30 a.m. on hearing sound, he has come outside with torch and noticed about 8 to 10 persons were removing cement and rod kept by the complainant. According to PW2, he would recognize the accused persons Piklu Chando, Orup Das, Orup Roy, Devangshu Chakraborty, and Bikash Bhattacharjee. PW2 further deposed that the accused persons have threatened him, showing Dao, Bhujali, and removed 30 bags of cement and 5 quintal of rod by hand cart. PW2 also deposed that when the accused persons left the raised alarm, he raised alarm and telephoned to the complainant, who reached the place of occurrence at about 5 a.m. PW2 in his cross-examination inter alia stated about not knowing the dag number as well as khatia number of the said lad, and he has not given any appointment letter as the watchman of the complainant. PW2 in cross-examination further stated that he is not aware who is the ward commissioner and ward where the complainant resides, and is also unable to say number of his mobile phone. Sushanto Sham PW3 inter alia stated that on 7/2/2010 at about 3:30 am, he was received a telephone from complainant that there were theft in the house of the complainant situated E&D colony. According to PW3, he approached to the place of occurrence where PW2 Dhananjay informed him that the present accused persons have removed 4-5 quintals of rod as well as 25 to 30 bags of cement by hand cart. PW3 further deposed that when then arrived at about 30 minutes after Dhananjay has informed him so and so. In cross-examination, PW3 inter alia deposed that Dhananjay Das has also stated to him that the accused persons have used two numbers of hand cart removing so and so. Decision. It is settled principle of law.
You can skip that.
I can
para
skip that,
six.
my lord. These are the so and so. Let me now come to
Para
six.
page 15:6.
Upon sifting of evidence or case records in the light of settled legal position, it is notable that PW1 has candidly specified about commission of theft of 5 quintals of rod and 30 bags of cement by the accused persons from his house situated E&D colony at about 2:30 am to 3 am on 7/8 February 2010, which was reported to him by the PW2, the watchman, by telephone, and PW3 has also corroborated his version in as much as PW3 has further specified being telephoned as such by the PW1, and PW1 and PW3 both being reached the place of occurrence later on the meeting, and PW2 who had narrated them the whole episode. Depositions of complainant side on the case record spilling out of PW2 Dhananjay Das, the watchman of the complainant, is the sole eyewitness of the whole incident, and upon scrutiny of testimony of PW2, I do not find any inconsistency in the same, and the statement of PW2 outlines the evidence and consequent credibility remained unshaken even after lengthy cross-examination by the defense, and evidence is direct and very specific. Thus, I consider PW2 a wholly reliable witness, inasmuch as not knowing the name of the ward commissioner as well as unable to decide the mobile number by a person employed as a watchman cannot be termed as unusual by a man of ordinary prudence. In the heels of evidence of PW1, PW3, it is clearly visible that both of them have reiterated knowing about the incident of PW2 from PW2, and their testimony further can be related to the evidence of PW2 without any ambiguity. And as such, I am also of the considered opinion that testimony of PW1 and PW2 can be relied upon. Upon evidences of PW1, 2, 3, it crystallizes that the present accused persons who were specifically identified along with others have committed trespass on the land in possession of the complainant in the dead hours of night and then removed rod and cement by hand carts, and as such there exists enough proof of physical act of lifting of rod and cement by the accused person, and such removal during the odd hours of night clearly projects the dishonest intention of the accused person so as to cause wrongful loss to the complainant. Following the above, it can be succinctly said that in the process, the accused persons have made a gain to themselves by unlawful means of property to which the accused persons are not at all legally entitled. Learned counsel for the defense arduously argued that the complainant side has not portrayed the description of the land, and as such, the accused persons cannot be settled with the liability offense alleged in this case, and as such, the alleged area of occurrence is not at all identifiable. I have considered the submissions to counsel for the defense, noting the facts and circumstances of the case. I am of the mindful opinion that even such argument cannot simply be brushed aside, or the fact of removal of rod and cement from the premises of the complainant by the accused person, as the portion of such testimony remain unshaken under the onslaught of the defense, and all the PWs have consistently coincided with the complainant's possession of the premises from which such removal has taken place. And counsel for the defense further tried to impress upon that it would be impossible to transport 5 quintals of rod and 30 bags of cement by 2 handcarts as deposed by the prosecution witness, further asserting that the said aspect clearly shows the doubtful nature of the complaint. On the other hand, learned counsel for the complainant side have heavily arguing that the testimony of PWs are specific and accused persons were accompanied by some other person as such using of manpower at their disposal at the relevant point of time. The accused persons have committed the theft of rod and cement. So, since testimony of PW2 is direct and no reason for PW to depose falsely against the accused persons is available on the record, accordingly, this argument propelled by the defense is found incapable of throwing a spanner in the complainant's claim. Learned counsel for the defense strenuously argued that the complainant, in his written statement in defendant's number 7, in title suit number so-and-so, nowhere mentioned about having any house as well as a claim of alleged theft, even though the written statement was laid down much later than the alleged date of occurrence. And as such, a clear testimony of falsity of the complainant's case, which got no legs to stand at all. Refuting such argument, learned counsel for the complainant present heard that the title suit number so-and-so is completely different lease from the present proceeding, which is contested in a different forum, and as such, the backdrop of potent and cogent evidence of the complainant's side on this case, which itself is sufficiently pointing out the guilt of the accused persons, such argument is devoid of merit. In the heels of the materials on record, I find force in the submission of learned counsel for the complainant, and the argument offered by the learned counsel for the defense is found short of satisfaction. Testimony of the complainant witnesses are cohesive and consistent, and the same unambiguously portray that the accused person, in concert, pursuant to their pre-arranged plan, trespassed in the premises of the complainant in the dead hours of night and decamped with the rod and cement, and such act of the suspicious criminal trespass as well as commission of theft in the present prior meeting on their mind. I have gone through the copy of the document submitted by the defense, and considering the same in the backdrop of the facts and circumstances of the case, I do not find that these documents are potent enough to negate the merit of the complainant's case. I have also reverently pursued the decision of so-and-so.
So you were finally convicted, they were finally committed under 447 and 379. 341, they were acquitted.
That's right, my lord. 341, they were acquitted.
So the punishment is at para 50.
Para 50.
Sentence is at para 50.
Only, my lord, 500 and 6 months, both concurrently. 6 months in prison and concurrently. Now, my lord will kindly come to the appellate judgment. Only page 22. My lord, this para 7. While perusing the evidence on record, it is seen that only PW2, who claiming himself to be Chokidar, under the complainant adduced evidence in implicating the accused person, deposing that he saw the accused taking away 5 quintals of rod, 30 bags of cement from the scheduled house and of the land of the complainant. He deposed to have seen 8 to 10 number of persons were taking away the said articles, and out of them could only identify 4 persons, namely the accused persons. My lord, they were the neighbors. In his evidence, he has said. He further deposed that at the time his mother and wife were also staying with him. The matter was reported to the complainant. Under the circumstances, a question may come as to why his mother and wife were not examined, corroborate the evidence. PW3 is reported witness. The learned court below seems to have totally relied upon the testimony of PW2 Chokidar. Had he been an eyewitness in the alleged occurrence of theft, he ought to have followed the accused persons to see where the stolen articles were stored. In absence of any such evidence, and also non-recovery of the seized materials by the IO during the investigation, shakes the very out the root of the prosecution case, as it is disclosed in the evidence that after commission of the alleged theft, on his raising alarm, people of the neighborhood arrived at the place of occurrence, and the matter was informed to them. Under such circumstances, the non-examination of any neighboring people and any other family members of Choki, the PW2, further corroborating corroboration, it is difficult to put complete reliance upon the testimony, especially into the fact that material time there were being pending civil litigation in the complainant as contesting a defendant, which the learned court below failed to take into consideration explicitly so and so, in view of so and so. So, my lord, this is a very cryptic. He did not, my lord, discuss the findings of the trial court, did not discuss the evidences which was relied on by the trial court. My lord, therefore, the appellate court has a duty, my lord, to look into consider the materials record again, and reasons given by the trial court ought to have been, my lord, discussed. This is not done, my lord, and it is a very perverse judgment passed by the appellate court, my lord. I can give your lordship. Your lordship is aware of the appellate court's power, my lord. They must look into, if we, my lord, reverse the finding, my lord, they has to give reasons why the learned trial court and where the learned trial court has committed. Only one paragraph. He has discussed the whole case, my lord. Nothing beyond that. Trial court, my lord, has in fact, my lord, given detailed judgment, looking into and discussing each and every evidences on record, and finally, my lord, found the evidences are. Lordship can look into the evidence of PW2, particularly cross. Nothing, no part is demolished by my lord, the accused persons in the cross examination of PW2.
Let us see this evidence of PW2.
Lordship.
Any cross with regard to impeaching him or something like that?
Nothing. PW2, my lord. I read it, my lord.
Just.
PW2. Dhananjay Das.
I don't claim my handwriting to be good, but to read this
My lord,
handwriting, you will require some.
I help your lordship. I'll read it out.
এই
মোকদ্দমায় বাদী বিজয়কৃষ্ণ দাস আমার পরিচিত। তিনি আমাকে পাহারাদার হিসাবে আদালত উপস্থিত নিযুক্ত করিয়াছে। গত মাসে রাত্রিবেলা রবিবার দিন ঘটনাটা হয়। আমি সেই সময় বিজয়কৃষ্ণ দাস জমিতে পাহারাদার হিসাবে কর্মরত ছিলাম। উক্ত বাদীর জমিটি ইএনডি কলোনির নিকট। সেই দিন আমি রাত্রিবেলা ঘুমে থাকার সময় বাহিরে শব্দ শোনা পাইয়া আমি ঘর হইতে টর্চ লইয়া বাহির হই। আমি বাহির হইয়ে দেখিতে পাই যে প্রায় 8-10 জন লোক রড আর সিমেন্ট ব্যাগস ঠেলাতে উঠাতে দেখলাম। Thela means, my lord,
No, it's not a handcut, that small one, it's a thela.
Thela. দেখলাম।
Thela means the big one, not the small one.
উক্ত মানের সঙ্গে সিমেন্টের ব্যাগ ঘরের ভিতরে ছিল আর রড ঘরের বাইরে রাখা ছিল। উক্ত সিমেন্টের ব্যাগ অন্য একটি ঘর বানাইয়া রাখা ছিল। উক্ত মামলার জমির বাউন্ডারি ওয়াল তৈরি করার জন্য বাদী বিজয়কৃষ্ণ দাস নিয়া রাখিয়াছিলেন। আমি উক্ত 8-10 লোকের মধ্যে প্রায় 4 জন লোককে চিনতে পারি। তাহাদের নাম পিকলুচন্দ্র, অরূপ রয়, দেবাংশু আর বিকাশ ভট্ট। আমি উক্ত বিবাদিত তারপরে লাইটের আলোতে চিনতে পারি। আমার সাথে সেই জমিতে ঘর করিয়া আমার মা বিশুপ্রিয়া দাস ও স্ত্রী তৃপ্তি দাস থাকতো। বিবাদীগণ আমাকে ধমকাইয়া হাতে থাকা দা ভোজালি দিয়া আটকাইয়া চিৎকার দিতে মানা করে। উক্ত বিবাদী তারা অন্য লোককে তাড়াতাড়ি মালপত্র উঠাইতে বলে। যখন মালপত্র নিয়ে বিবাদীর সাথে থাকা লোক ঠেলা নিয়া চলিয়া যায়, তারপর আমি বিবাদী তার কবল হইতে রক্ষা পাই। বিবাদী তারা 30 ব্যাগ সিমেন্ট আর 5 কুইন্টালস রড চুরি করিয়া লইয়া গিয়াছিল। উক্ত ঘটনা রাত্রিবেলা আনুমানিক 2:30 ঘটিকায় সময় হয়। বিবাদীদের তারা যাবার পর আমি চিৎকার দিই। আর তার চিৎকারে আশেপাশের কিছু লোকজন আসিয়া উপস্থিত হয়। তারপর আমি বাদী বিজয়কৃষ্ণ দাসকে ফোন যোগে ঘটনার কথা জানাইতে বাদী সকাল 5টা ঘটিকার সময় আসিয়া পায়। বাদী আসার আগে উক্ত স্থানে সুশান্ত তার উপস্থিত হইয়াছিল। আমি আমার মালিক অর্থাৎ বাদীকে ঘটনার কথা বলি। দেন দি ক্রস। আমি 2-3 বৎসর ধরিয়া করিমগঞ্জ টাউনে আছি। আমি বাদীর নিকট থেকে 2.5 ইয়ার্স ধরিয়া কাজ করিতেছি। বাদীর ল্যান্ড ফ্যাক্টরি ভাড়া করতাম। ফ্যাক্টরিতে আগে ভাড়া করতাম। আমি পাহারাদার হিসাবে প্রায় 1.5 বছর ধরিয়া কাজ করিতেছি। আমি বাদীর উক্ত জমিতে পাহারাদার হিসাবে কাজ করিতেছি। আমি উক্ত জমিতে ঘাটি পাহারা দিতেছিলাম। উক্ত জমির দাগ নাম্বার খাতিয়ার নাম্বার আমি বলিতে পারিব না। ঘটনাস্থলীর আগে হইতে বিবাদীরা তারা বাড়ির ঘর প্রায় 100-150
The distance between the house.
7 feet.
They are neighbors, accused are neighbors.
বিবাদী তাহার নাম পূর্ব দিকে থেকে আমার জানা ছিল। He knew their names. গায়ের লোক আমাকে দা ভুজালি দিয়া ধরিয়া রাখিয়াছিল। বাদী বিবাদীগণ বাউন্ডারি হইতে বাহির যাবার পর আমাকে ধৃত বিবাদীরা আমাকে ছাড়িয়া দেয়। সেই আমাকে আদালত উপস্থিত বিবাদীরা আমাকে ধরিয়া বসেছিল। ফার্দার ক্রস অ্যান্ড দেন নেক্সট। আমরা বাদীর পাহারাদার ছিলাম। নিযুক্তি দেওয়ার কোনো কাগজপত্র আমার নিকট নাই। পাট্টা গ্রাম কাহার বর্তমান আরকে নগর PS অন্তর্গত। সেইখানে আমি ভোটার হিসাবে ভোট দেই নাই। করিমগঞ্জ টাউনে আমার ভোটার লিস্টে জমি ভিটা নাই। আমার নিকট দিন ধরিয়া করিমগঞ্জ টাউনে থাকার প্রমাণপত্র আমার নিকট নাই। আমি বাদীর বাড়িটা ওয়ার্ডে সেই বলিতে পারিব না। কোন ওয়ার্ডে বলতে পারিব না। আমার মালিকের বাড়ি সেখানে ওয়ার্ড কমিশনার কে বলিতে পারিব না। অনলি ফ্যাক্টরিতে প্রায় 3 বছর কাজ করি। আমি 250 বা 300 টাকা ডেইলি ওয়েজ হইয়া পাইতাম, কিন্তু তাহার কোনো কাগজপত্র নাই। আমি বাদীর ফ্যাক্টরিতে কাজ করার সময়ে শ্যামাপ্রসাদ রোডে একটি ভাড়া করেছিলাম। সেই ফ্যাক্টরি মালিকের বাড়িতে অবস্থিত। আমি নিজের নামে রেশন কার্ড নাই। ওখানে দাদার সামগ্রী ওয়ার্ড আমি বলিতে পারিব না। বর্তমানে আমি আছি, দ্যাট ইজ ভেরি ইলিজিবল। সেখানে প্রায় 2 বছর ধরিয়া বাস করিতেছি। আমি কেমন 2 বছর আগে পাহারাদার হিসাবে যাই, তখন বাদীর বাড়িতে ঘর বানানো অবস্থায় ছিল। আমি বর্তমানে কে বাড়িতে সেই বাড়ি হইতে চিৎকার শুনিতে পাইয়া কাহার প্রতিবেশীর লোক শুনতে পায় যে আমি বলিতে পারিব না। আমি কালীপদ দাসের বাড়ি চিনি না। আমি শিবুপাল, জহরনাথ, চন্দন চৌধুরী তাহাদের চিনি। উক্ত লোকজন আমি শাখাভূমির নিকট প্রতিবেশী লোক। উক্ত লোকদের নেইবার্স। প্রতিবেশীর সঙ্গে আমার কোনো সম্পর্ক নাই। সরেজমিনে ঘটনার পরে আমি চিৎকার দিলে চৌধুরী ও বাপন চিনিকে আসা দেখা পাই, কিন্তু বাকি কেহর পাহারা আছে আমি ভালো দেখি নাই। চন্দনের বাড়ি এবং আমার বাড়ি লাগা বাড়ি। বাপন রক্ষিত কোনো ওয়ার্ডের মানুষ আমি চিনি না। বাপন রক্ষিতের বাড়িতে থাকা তাহার মালিকের নাম জানি না। বাপনের সঙ্গে আমার পূর্ব থেকে পরিচিত নাই। আমার নামে মোবাইল ফোন আছে, কিন্তু কি নাম্বার বলিতে পারিব না। আমি অতীতে সেই মোবাইলের দিয়া ঘটনার কথা জানাই এবং মোবাইল নাম্বার বর্তমান বলিতে পারিতাম না। এবং কত রড ছিল আমার ছিল বলিতে পারিব না। কি কোম্পানির ব্যাগ সিমেন্ট ছিল তা আমি বলিতে পারিব না। ঘটনার সময় কোনো মেশন কাজ করিতে দেখি নাই। আমি বিবাদী সবাইকে চিনি, আর তার তিনজন বিবাদী দেবাংশু চক্রবর্তী, পিকলু চন্দ, অরূপ রয়ের বাড়ি চিনি, কিন্তু তাহার বাড়ির আমি পাশের লোকজন নাম বলিতে পারিব না, আশেপাশে বলতে পারবে না। ঘটনার সময় বাদীর জমিতে অর্থাৎ ঘটনাস্থলীতে কোনো ইলেকট্রিক্যাল কানেকশন ছিল না। ঘটনার সময়ে বিবাদী কোণের
Just read that line once more.
বলুন,
That electric connection.
তার বাড়িতে আসে, পাশের লোকজন আসে বাড়িতে। ঘটনার সময়ে বাদীর জমিতে অর্থাৎ ঘটনাস্থলীতে কোনো ইলেকট্রিক কানেকশন ছিল না। ঘটনার সময় বিবাদীগণের মুশখুলা দিক ঠিক বিবাদীগণ কি সময়ে কাজ করা আমি বলিতে পারিতাম না। বিবাদী দেবাংশুর সঙ্গে আমার আগে হইতে পরিচিত। বিবাদী দেবাংশুর বাড়িতে আমি ঘটনার এতদিন আগে যাই আমি বলিতে পারিব না। আমি বাদীর ভূমিতে বিনা বেতনে পাহারা দেই। আমি নিজের জীবিকার রাজি এবং আমি স্ত্রী সন্তান। ঘটনার রাত্রিতে শীতের ভাত ছিল আর পাহারা এবং উইন্টার সেশন অর্থাৎ বলেছিল। আমার পরিবারের লোকজন আমাকে পারে না, কারণ বিবাদী তাহাদের ধমক দেয়। দরজা পাশেই বিবাদীগণ আমাকে আটক করিয়া রাখে। পরের দিন 11টার সময় পুলিশ ঘটনাস্থলীতে আসে। পুলিশ আসার পর বাদীকে উপর অন্য মানুষ ঘটনাস্থলীতে উপস্থিত ছিল না। সিমেন্ট রাখা রুমটির তার দেয়া ছিল। আমি মালিক বাদী পুলিশকে সেই রুম দেখায় কিনা আমি বলিতে পারিব না। বিবাদীগণ 2টি হাত ঠেলা দিয়া সম্পূর্ণ মাল তুলিয়া নিয়া দেওয়া আমি দেখিতে পাই। কতজন অর্থাৎ লোক ঠেলা চলিয়াতে নিয়া যায়। বিবাদী যাহারা আমাকে টিকায় তাহারা এর পর্যন্ত আমাকে আটকাইয়া রাখে। এটাই সত্য নয় যে আমি বাদীর পাহারা দেই এবং বাদীর পাহারাদার এবং আমি সাক্ষী দেবার কোনো হয় নাই। This is some suggestions that have been given. This is the evidence. So my lord, trial court has considered the entire evidence, found nothing has been. So the appellate court, if my lord wanted to reverse it, ought to have discussed the findings of the trial court and then my lord come to the finding, his own finding. After considering the evidences on the court. The appellate court did not do that, did not read the evidences at all. And then arrived at a different finding. So if the appellate court also have a different view, my lord, views expressed by the trial court ought to have been accepted, because trial court is seeing the person deposing before him. Trial court has an additional advantage, my lord.
Okay, Mr. Roy. Anything else?
So that's all. I can, Lordship, I can end up a decision. Only paragraph 16, 15, 16. The appellate courts. There are others, but I don't bother Lordship with other.
Chambal. Para 16. Okay.
Here in this case,
Hmm.
the trial court conviction was given basically only on the basis of the PW2, the only eyewitness. In the eyewitness, my lord, in his deposition, he specifically stated that when this theft took place, neighboring people came. Name has also been mentioned. They were not examined in this case. And apart from that, there was an affair. But initially, affair before the police. May I read that affair, my lord, first?
It's not on record, I suppose. It's in the
It is on record.
in the
LCR, yes.
okay. LCR it will be there.
LCR. It is in the LCR.
Okay, got it. Yes.
সম্মানপূর্বক নিবেদন এই যে আমি not exhibited, I have obtained the certified copy from the record.
No, naturally, it will be here only. Officer in charge, Karimganj PS Sadar.
Yes.
16 to seen on 16 to 10. No.
Yes.
Hmm.
It was, my lord, the affair was filed on 8/2/2010. সম্মানপূর্বক নিবেদন এই যে আমি সহিংস বছর খানেক পূর্বে এনডি কলোনিতে বিবেকানন্দ পাঠশালার নিকটবর্তী একখানা জমি ক্রয় করিয়াছিলাম এবং সেই ক্রয় করা জমিটি ও বর্তমান সম্পূর্ণভাবে আমার দখলে বটে। বিগত দিন কয়েক পূর্বে আমি আমার ক্রয় করা মাটির বাঁশের বেড়া উঠাইয়া স্থায়ীভাবে বাউন্ডারি ওয়াল দেওয়ার জন্য 5 কুইন্টাল রড ও 30 বস্তা সিমেন্ট এবং অন্যান্য সামগ্রী আনিয়া রাখিয়াছিলাম। কিন্তু বিগত 7/2/2000 ইংরেজি তারিখে রবিবার রাত্রি আনুমানিক 2:30 ঘটিকার সময় নিম্ন তপশিল বর্ণিত ব্যক্তিগণ আমার উক্ত জমির ভিতরে প্রবেশ করিয়া আমার বাসার নিযুক্ত থাকা পাহারাদারকে ধমকায়া উপরোক্ত বর্ণিত সামগ্রীগুলি সঙ্গে করিয়া নিয়া চলিয়া যায়। এমত অবস্থায় আমার পাহারাদার শ্রী সোয়েন্স দাস হাল্লা চিৎকার করিলে প্রতিবেশী কয়েকজন লোক আসিয়া ঘটনার বিবরণ সাক্ষ্যে দেখিতে পান। এমত অবস্থায় প্রার্থনা এই যে সোয়েন্স then police investigated the matter. Now after investigation, police what was found in the final report, my lord, that is also on record, my lord. Final report, may I read final report, my lord? The brief history of the case is that on so-and-so, the brief history of the case is that on 11/2/2010, 7:50 p.m., complainant Vijay Krishna Das, so-and-so, Tilak Chandra Road, so-and-so, laws at the PS to the effect that on 7/2/2010, 2:30 p.m., accused Devanshu Chakraborty, Piklu Chanda, Orup Roy, so-and-so, all resident of so-and-so, trespassed into the boundary of the complainant and stolen away the road, cement, etc. from his boundary with the intention with some intent. Hence, the case was registered and duly investigated.
During investigation, PO was visited, draw the sketch of the PO and examine the available witnesses. And from the examination of witnesses, it reveals that there is a dispute between the complainant and FIR named accused person for possession of Vivekananda school land. The school committee, these accused are at that point of time the committee member of the school committee. The school committee and the document of the school sold the land to the complainant Vijay Das, and the agreement is that from the school about 6 feet land given to the complainant for his house path. In this regard, accused person and other local people objected the matter. As a result, the quarrel took place in between the complainant and FIR named accused person. No any evidence found under section so and so against the FIR named accused person, and this is no materials left by the complainant for constructing the boundary wall. Accordingly, I now consult with the OC Karimganj PS about the case, and he suggested me to submit FIR as so and so, so and so. Under the above facts and circumstances, I beg to return the case of FR under section so and so. Hence, accused person could not be arrested and they are in discharge from the case. The of investigation has been communicated to the complainant accordingly. After this final report, my lord, they have not petition has been filed against this. They have filed the present complaint case. Now, after
Here's the complaint case.
Complaint case. And in the complaint case, the GR case, my lord, initially which was registered as GR number 120 of 2010. In that GR case, police also recorded statement of the complainant. That statement also I have, my lord. May I read that statement? আমি এই মোকদ্দমার বাদী এবং এজাহারকারী আমি
That is 161 statement.
161 statement. মানে করিমগঞ্জ এনডি কলোনিতে একটি যোগ্য খরিদ করিয়া একটি জায়গা খরিদ করিয়া কাঁচা বাঁশের অতীনের একটি চালা প্রস্তুত করিয়া আমার পাহারাদার ধনঞ্জয় দাসকে তার সপরিবারে ওই ঘরে থাকিতে দেই। আর আমি অতর্কিতে আমার স্কুল বাউন্ডারি ওয়াল প্রস্তুত করার জন্য স্কুল বাউন্ডারি ওয়াল ব্রিক and sand and stone 5 কুইন্টাল রড ও 30 ব্যাগ সিমেন্ট খরিদ করিয়া সেই নিচে জমিতে রাখিয়া বাউন্ডারি ওয়ালের কাজ করিতেছিলাম। ঘটনাস্থল গত 7/2 এত তারিখে রবিবার রাত্রে 12টার পর অনুমানিক 2:30 AM আমার পাহারাদারের নিকট একটি ফোন কল পাই। সেই কতগুলি লোক আমার জমি হইতে আমার খরিদ করা রড আর সিমেন্ট চুরি করিয়া নিয়া গিয়াছেন। So before once in 161 statement, he did not named any person, even of this present accused also. He did not named. টাকা লইয়া আমি সকাল ভোরবেলা ঘটনাস্থলিতে গেলে
But the persons have been named in the FIR.
In
the FIR.
FIR.
Everybody Nam?
নিম্নত below
around
yeah.
4 are there.
4 are there.
So you 4 are there.
Yes. And this statement was recorded
Fine.
on Statement was recorded.
Now tell me, the appeal, in the appeal, the only, many things you have said.
In the appeal, my lord,
In the
whether,
appeal, para 7 is the only thing.
whether only on the basis of PW2 can the accused can be convicted or not.
Where is
Because-
the bar, Mr. Ghosh? Where is the law in the country that you must have this much number of witnesses
No,
to convict a person?
but
It's
but
the quality.
there in the defense which has been
You
taken-
have not dislodged in the
in the defense it has been dislodged.
No.
Because in somewhere it stated that two named person who are the neighboring witnesses came to the place of occurrence. They did not examine.
No,
And-
Mr. Why are you
apart
on
from
the
that,
examination? You
he-
be on the
One
statement.
sentence is said that he is the
See,
the
you have
chokidar.
in detail, you have cross-examined PW2. The questions asked are unnecessary. You have not asked him how he could identify you. How did he see you? It was night. These questions are not there.
In a question was there that at whether there was any electricity.
He said
or
that
not.
in that,
no
that
electricity
he
was
said
there.
no electricity, but you did not ask him how he saw you, how he identified you.
And
See, he has said that these four, they are nearby. Pratyabhaki, they are nearby. So I know them with their voice. The village people, they know them people by the voice.
But at the same time, can this evidence be believable that 2-3 quintals of rod and 30 bags of cement
where is
in
that?
two
Where
pulkas?
is that question you have asked? Hatot Thela, that big Thela, not the small one.
No, thela is thela. Thela size is 2 thela. By 2 thela, can it be possible 30 quintals
100%,
of
100%.
rod and 30
That has been
bags of
dealt with by
cement?
the learned trial court.
30
There
bags
were
of
around
cement.
10 persons involved. That has been gone into by the trial court.
So,
You tell me how this para 7 can be sustained of the appellate court order.
My lord, para 7 is sustainable because it is not a believable story which has been made out by the.
He does not say. He
Apart from
says,
that,
see the conclusion.
apart from that, my lord, there was a pre-title suit between the school committee and between the informant. School committee and in the informant, there was a suit with respect to this disputed land.
You come to this para
And
7.
in the PW1, cross-examination said that yes, school committee allow him to enter
That
into
is
his house.
in your title suit, which you have already lost. Now it is
No,
pending
it
second
is,
file. So in the second appeal.
in the representative capacity, title suit has been filed.
Be that as it may, you have gone. You have lost it. Decreed against you.
No, not
Appeal-
decreed against us. It was only suit was dismissed. Then appeal is pending.
No, second appeal is pending.
Question of decree will come
Second appeal is pending.
pending. Yes.
Okay, fine. 2 forums you have
And
lost.
apart from that, my lord, with respect to this
Mr.
PW,
Ghosh,
it
again,
is not a believable story.
okay, fine, we noticed. Now you come to para 7 of the judgment and just satisfy me that this is maintainable.
Para 7 of the judgment of the
Appellate court.
Appellate court. Para 6 from para 7. While perusing the evidence on record, it is said that only PW2, who claiming himself as a chokidar under the complainant, adduced evidence implicating the accused person, deposing that he saw the accused taking away 5 quintal of rod, 30 bags of cement from the scheduled house and land of the complainant. He deposed to have seen 8 to 10 numbers of persons were taking away the said article, and out of them he could only identify 4 persons, namely so-and-so and so-and-so. The matter was reported to the complainant. Under such circumstances, a question may come as to why his mother and wife were not examined to corroborate his evidence. PW3 is a reported witness. The learned court below seems to have totally relied upon the testimony of PW2, the chokidar. Had he been an eyewitness
That
of
is the reason. That is the reason.
occurrence of theft, he ought to have been followed the accused person to see whether he has stolen the article were stored.
What is this reasoning?
And this article, my lord.
No, what is this
it was
reasoning?
police could not, this
See,
is,
I am only
this is
concerned
not a
with the-
small article. Police could not
Mr.
able
Ghosh,
to,
we are not concerned with anything else. We are concerned with what is there in para 7. Para 7, the learned trial court, appellate court had come to a conclusion that the learned court below seems to have totally relied upon the testimony of PW2, the Chokidar. Now, after that, he says, why did you not go and look? Where is the requirement in law? That if you, there is a theft, you have to follow the theft.
my lord, there was a police case. Police could not able to recover this item also.
Fine,
This
that
not
is
a
the failure
small-
of the police.
This is not a small item.
In absence of a non-recovery. Non-recovery is, that is a, but whether the factum of that theft has been dislodged, I'm sorry, it has not been.
Only 30 bags of cement and 5 quintals of rod has been stolen,
This reasoning, I'm
and
sorry.
nothing has been recovered.
Okay, this reasoning we are not accepting. If you have something more to say, you can tell me.
Well, Lord, apart from that, no witness, no other witnesses was
Where is the
corroborated.
requirement, Mr.? That there must be X number of witnesses. You have not
My
disclosed.
lord, this is a criminal
You have not
trial.
disclosed
This is a
PW2.
criminal trial, my lord. There was some benefit of, some benefit of doubt is to be gone in favor of the.
What is that benefit of doubt you want?
Here is
This is not the benefit of doubt that he did not go and looking for the material where it was taken. That cannot be a
Lord,
ground. That is the ground cited here.
My lord, whether only on the basis of.
Show me any decision on that. Any decision that this is the reason.
Conviction can be,
You show me any decision.
when other evidences has not been discussed. By the
See,
trial court also.
Another thing, the trial court had gone deep into 3, 2, everything. But the appellate court with one line saying that he did not follow the thieves.
Not only follow, recovery.
No, that is the first thing. Recovery is not with regard to P2. PW2. Recovery is not with regard to PW2.
Lord, recovery is with respect to
The
with
incident.
respect to the incident.
Incident. But dislodging PW2, this cannot be.
And PW1 also, in his statement, stated that there was a previous title suit pending between
we are not concerned.
between the parties.
That we are not concerned. That may be a reason why you had done this. To prevent him from creating a boundary wall.
If that may be a reason, it goes in favor of the accused. Because
Anything more?
There is a doubt.
Anything more? How old are you all now? How old are you all now?
All are old person. They were at that point of time was the member of the school managing committee.
We uphold the conviction but give you probation of under the Probation Act. No sentencing. Done. Be disposed of. We'll interfere with the trial court, appellate court order, uphold the conviction by the trial court, but give you the benefit under the Probation of Offenders Act. No jail term. Be happy with that, sir. What? Yes, Mr. Doctor, what are you waiting for? Oh. Oh, you want me to admit that matter? Then fix it for hearing. Record has come. No. Yeah, 65. I'm sorry, I'm slow. I can't.
No, sir.
Not been able, because the old matters will require some hearing. Oh, this is a new matter.
New matter, statutory appeal.
Why is this come in admission? Oh, appeal.
Appealment. Additional decision.
Sorry. But Mr. B. Learned Senior Counsel, assisted by Mr. J. Das, Learned Counsel for the petitioner, for the appellant. Also heard Mr. R.J. Burwa, learned additional public prosecutor appearing for the state respondents. The present appeal has been instituted under Section 415 bracketed 2 of the BNSS, 2023, assailing the judgment dated 27/6/2025 and order dated 30/6/2025 passed by the learned additional session judge bracketed FTC bracket over number 2 Tinsukia in section case number 52 bracketed CH oblique 2021, convicting the appellants under section 341/342/304 bracketed 2 34 IPC and sentencing them to undergo rigorous imprisonment of 10 years and to pay fine of ₹50,000, in default, to undergo a further term of simple imprisonment for 6 months for the offense under section 304 bracketed Roman number 2 bracket over IPC. Also, a semicolon with simple imprisonment of 1 month and to pay a fine of ₹500, in default, to undergo a further term of simple imprisonment for 15 days for the offense under section 341 IPC and with rigorous imprisonment for 3 months and to pay a fine of ₹1,000, in default, to undergo a further term of simple imprisonment for 1 month for the offense under section 342 IPC. Also, they said sentences were directed to run concurrently. Also, issue notice. Mr. R.J. Burwa, learned additional public prosecutor, has appeared for the state respondents, for the sole respondent. Also, registry to call for the trial court records from the trial court records. Full stop.
Only my request, my lord, the one lady is also under the imprisonment. You fixed a date, my lord, trial court record may come.
The registry to list this matter, to requisition the trial court records, trial court records within a period of a week from today. Registry to list this matters again immediately upon receipt of the trial court records. Full stop. Then we'll see what can be done. Yes, Mr. Mahmood.
Get. Lordship. My lord, this is a case of 2006. I'm telling the study first, that will make the matter easier to understand. This year Ali, who was the driver, and he had a Maruti vehicle. 3 young boys came at Borpeta Road. And they said that we will go to Gwalpara, and the rent, the fare was fixed as ₹1,000. After Gwalpara, they went to Gwalpara and they're coming back by the national highway. When they reached near Bijni, at a place, it is called Shialmari. At Shialmari, it is alleged that the 3 boys stepped and caused him various injuries. And thereafter, his vehicle.
And unfortunately for the accused, they met with an accident. Which led to their arrest.
Yes. And the accident of the vehicle took place within Shorvak police station.
So what is there? What is the error?
And the error means, well, there are, of course.
307 taken out.
No.
You are not found guilty under 307.
No, 324.
You are found under 324.
And 394.
394, 2 sections. And the punishment is very lenient.
No, my lord, yes, there are some points.
Yes, what are your
points? Yes, I will explain. Lordship, perhaps Lordship would not deliver the judgment today. Tomorrow I will give some judgment, a citation on this. Tomorrow I want to, because today.
As prayed for by Mr.
No,
M.U.
no,
Mahmood.
I am ready to argue the case.
No. Tomorrow with the judgments we'll hear. I'll pass the order. I'm ready with the matter. Mr. Mahmood, heard Mr. M.U. Mahmood, learned counsel for the appellant. Also heard Mr. M.P. Burwa, learned additional public prosecutor appearing for the state. So hearing remains inconclusive as prayed for by the learned counsel for the parties. The registry to list this matter again by slip query tomorrow as a top of the list matter. You just show me, otherwise I'm ready. You just show me how we can.
Regarding the FSL report is not there. The blood stain clothes were recovered.
But what about the witnesses, your cross?
Cross is not so.
Nothing is
that diminish
nothing is there.
But
Right.
legal point, I think some leniency would be there.
No leniency for this sort of offense.
So it may, considering the old case, it may be converted to fine also.
No. With this sort of thing, I'm sorry. This court would be not.
Let me try to say.
No, that's why I'm saying you try, but tomorrow. You do.
Lordship, this is that Partha GST matter, Lordships. Wherein Lordships had requested me on the last occasion and heard me, Lordships, regarding the issue of 1718, when the audit was already completed. Can a subsequent show cause notice could have been issued on the same allegations of the turnover which was dropped under section 65(6)? And after extensively.
Yes, any further clarification?
Regarding this matter, I do beg to apologize to both as well as to your Lordship. I request some short accommodation because the main counsel is on legs in court.
Lordship, we had filed our written notes of arguments also on the last occasion.
But Mr. Counsel Kanodia, the problem is that my jurisdiction has changed. Now I am I'm a criminal.
Lordship,
I'm a criminal now.
Lordship,
So if the matter is not taken up,
Lordship, kindly fix this on Tuesday. I am appearing physically, Lordship, on some
no,
matters.
Tuesday it's filled with 12, 13
Lordship,
and 13 criminal matters.
Lordship, part third matters.
Matter.
Lordship, I will not submit anything. My other side will submit for 5 minutes. I will not open my mouth. I will come
How can you limit their argument to 5 minutes?
Lordships, my written notes are before your Lordships.
Okay.
I cannot.
A prayer is made on behalf of Mr. B. Gogoi, learned counsel for the petitioner, for an adjournment in the matter. Also, prayer accepted. Registry to list this matter again on 23/9/2025 at 2 p.m. Please complete it.
Yes, Lordship.
Mr. A. Kanodia, learned counsel for the petitioner, is present online. Also, you come online, need not come. Your notes are here.
Lordship, thank you. Grateful, dear Lords. My Lords. Much obliged.
Tomorrow morning, Lordship, I have mentioned to take this matter along with criminal appeal number 351 of 2020.
Same matter.
Here in this case, this is that is the cross case, Lordship. So both has to be
heard together. There is an appeal from the cross case also.
Yes, sir.
Okay, Mr. A. Ahmed, learned counsel for the petitioner, submits that basing on the same incident, a cross case was also instituted by the respondents herein, right? By the respondents herein, which is now pending before this court in the form of a criminal appeal, being criminal appeal number
351 of 2020.
351 of 2025. Full stop. Registry to verify the said matter and list the present case along with criminal appeal number 351/2025.
PW4 and PW8 of present case is convicted in that case.
All the respondents had instituted that case together.
They are also witness to that case.
Okay. बाकी ऊपर की हुई नहीं सब
If this item, Lordship, I am praying for adjourn the matter.
Why?
Lordship, the conducting council,
Your name?
K. Thakur, my lord.
A prayer is made on behalf of?
On behalf of S. Yasmin.
Huh? Yes, Yasmin, learned counsel for the petitioner for an adjournment in the matter on the ground of personal inconvenience. Prayer is not objected to by the learned public prosecutor, learned additional public prosecutor appearing for the state. Also, registry to list this matter again after 3 weeks on a date to be fixed by it.
My name K. Thakur, my lord.
Yes, ma'am. Seen the office note dated 6/9/2025, the lower court trial court records as a requisition has not been received. Registry to issue fresh requisition for the said trial court records along with the case diary. Also, registry to list this matter immediately on receipt of the trial court records.
May I please, your lordship? The judgment and order, lordship, filed by the lordship, tell that the plea in the POXO case number 3 of lordship. Lordship. Action is a lordship. And 4 of a POXO. Well, that has not been proved.
Now you come to your page 118 of your affidavit. And this is strictly in terms of this you have done it.
There is no dispute, my lord. I am not disputing. But this is the decision taken. And lordship will see how it was processed.
Well, I've got it. I've got it. This is only with regard to this aspect that is there in page 2.
Lordship will see down below. You have note number 42. Note 42. As per instruction of owner, for cancellations are end.
Very good.
And lordship will see.
Nothing like it. You have done it for a good purpose. But now my question is.
Note 46, my lord.
I got it, mister. But now you come to page 118.
I have seen that, my lord.
Why the first part was not ignored? Why the first part was ignored and the second part taken up? There has to be an explanation for that. It's not there. To cancel the engagements made recently as well as any ongoing recruitment process. So as well as ongoing recruitment process, 50?
Of action taken report, points of review, meeting of Health and Family Welfare Department chaired by Dr. On so and so is as directed, following actions to be taken. Or we will see.
Where is this minutes?
Part of the.
Where is the minutes? So if that order is modified, if that earlier order is
brought to the notice of the highest.
Show me how it was dealt with. Where is the minutes?
Actually, that I am placing, my lord. What has happened is there was a splitting files. The lordship may, if there is a paging number 73, note number 73. 73. This file was attached so and so. Name is thereby sent back for necessary action. It was and my lord, to my knowledge, my lord, it is
which their case.
That it was segregated because there was 2 files, my lord. We had to segregate. One direction was that we must immediately take up a reservation policy. Now we have brought in, but to process that, my lord, particular cancellation, we have to do it immediately. So it was bifurcated.
Okay.
That's why.
Now, where is that minutes that you are there? It is there in
review committee.
Review committee. How it was dealt with?
In fact, my lord, I like to
as my lord, the present petitioners, my lord, bets is concerned. While it was processed, lordship will find their part, my lord, page 123 for a moment
Of your affidavit.
of my affidavit. I have placed the note sheet.
Hmm.
We were processing it, my lord. In the meantime, this came, my lord. And there are 54, my lord, persons in this particular bets relating to the petitioner. For the, my lord, media expert is only, my lord, 12. Now, lordship will see it was processed. In the next page, 124, forwarded for kind approval, list prepared as per.
Yours are district media expert, no?
No, no.
Yours is
my lord, only rehabilitation worker.
rehabilitation worker. This is district media.
No, this is, my lord.
This is district media.
Yes, yes. Thereafter, lordship will find it page 127. So far as the petitioner. 27. Lordship will see, my lord, all these chart 54. Petitioner's names are there within this. Page 129, put up for kind approval, forwarded for kind approval.
When was this forwarded?
Lordship will see, my lord, 29/2/24.
Where is the date?
Just below the chart, my lord.
Okay,
129.
29/2/24.
Then, my lord, again 29/2, it went to ED, Executive Director, then MD submitted for approval, chairperson is. In this manner, it was, my lord,
Approved.
it was, my lord, otherwise.
What is this at page 130, top one?
130. May kindly approve.
Please may kindly approve. No, one top one. A mission director, digitally signed. It is.
Yes, at the top, my lord. Yes.
And it was approved on 12/3/24.
So then, lordship will see again, may kindly approve. It went to Commissioner, Secretary, Government, Government. Then Minister, my lord,
12/3/24.
Health Minister, my lord.
Health Minister 12/3/24 approved.
Then it was under process. MD, NSM, so and so. Lordship will see down below.
Engagement order 17.
Yes, was placed and so, put up for kind approval. Again, my lord, these are the process we have followed in the other bets also. Everything is there, my lord.
So their thing was approved
Yes.
on 12/3. Now let us go back to the minutes.
Their part, my lord, was taken up within this category. There is ongoing recruitment process. Not that, my lord, arbitrarily or with some malified intention, my lord, they have not.
No, we are not that. We are whether you have done the action.
And lordship will see, my lord, page 118. At the top, lordship will see on 3/7/24 it was received.
So where did you show me now that these are the categories that you will be now?
Yes, my lord. It's that lordship will find in the affidavit also in the chart, my lord, we have given. At page, my lord, 121. Categories: advertisement issued but interview yet to be conducted, results declared but posting to be done. So petitioner falls under this category.
So Mr.
104.
That's what I'm saying. This is the only three category wherein you have part.
In this manner.
But how will the petitioner's thing come here?
No.
Advertisement issued but interview yet to conduct. Result declared. I'm coming. Result declared but posting to be done. Interviews have been conducted, results under process. Here, everything is done. Their results have been declared.
No, number 2, lordship will see again.
Results declared but
postings to be
posting.
done.
Okay.
In the writ petition, they have annexed the posting order of the, my lord, media experts. That's why I'm saying, my lord. Posting experts, lordship will see, my lord.
When was the media experts posting done?
18/6. 12%, lordship will see page 89. This is how, my lord, it is uploaded in the website. We were doing it genuinely, my lord. It's nothing, my lord, that we have.
18/6. They were posted. And these people, their approval was given on 12/3.
While my lord, this draft was being prepared, suddenly, my lord, we got this order and we had. There are only 12, there is 54. So sometime probably, ultimately office it was going on. Not only in this particular advertisement, 6 other advertisements has been cancelled.
So you give me that minutes.
My lord, I will place.
When?
Anytime, my lord, it's from Guwahati only. Any day convenient
Mr. This affidavit has been filed today.
is today. Lordship may call it for the record, my lord.
Mr. B. Gogoi, learned additional advocate general appearing for the state respondents, has submitted that an affidavit on behalf of the mission director, National Health Mission has been, that is the respond number 2 hearing, has been filed today. First, copy of which has already been handed over to the learned counsel for the petitioner. In view of the above, registry to trace and tag the said affidavit along with the records of this case and list the same. Again, which one?
I would not appear online.
Wait. 22nd, 22/9/2025. We'll see on that day. And if you want to file an
Whatever
affidavit,
is there, my lord, regarding review, I will place everything, my lord.
only thing satisfied is court
Yes.
as to why the first aspect. One way of doing it with regard to that minutes. If in the minutes it has been taken
Only,
up
my
and
lord, my submission will be, my lord, sir was appointed, not only, my lord, the media experts, majority were doctors. We are in urgent need of doctors. So that part we have to.
these are poor people, they have
No, I
got
understand, my
something.
lord. Then my lordship may some observation that, my lord,
We'll see.
if they appear in the future, some, my lord,
That is like giving them a
so
sweet.
that can be done, but because, my lord, they were selected.
They were selected, they were there, they were approved.
And, my lord, it was not cancelled on some, my lord, that there's some irregularity.
No.
That part, of course, some.
No, it's a decision, you have applied it across the board, but I only want to know, there are 2 parts to that decision. Why the second part was implemented, not the first part?
I do get hold of that, my lord, report from the health.
Why this first part was not done? If it was done, it should have been done across the board. Reservation is something which is.
They will come running to the honorable court again.
Let them come. Let them come. Let the decision be applied in the manner it is to be. But just show me that minutes.
Yeah, I
That
will
may
take.
show some
In
light.
fact, subsequent to that, there was.
I'm only trying to understand, Mr.
Yes.
I am trying to understand only. I can understand your projections, but let me also be satisfied.
Other
hearing, Lordship, otherwise.
Yes, let it go.
Further hearing.
Obliged.
Ivan, হয়ে গেল?
39 Martin.
হয়ে গেল নাকি সব?
সব মানে
Orders mana?
delivery.
না, এই তো orders কিনে মানে deliver to my hearing there.
IA is for consideration of bail. 5 years conviction, your lordship. Under POCSO, your lordship. 10, your lordship. Already 1 year, 3 months, your.
Yeah, behind the bars.
Behind. Considering that aspect, your lordship.
This is POSCO.
POSCO, your lordship. 5 years, your lordship, and 10, your lordship.
Who is for respond number 2? Yes, what is your ground?
Lordship, so far as my grounds are concerned, your lordship, trial court, your lordship, while considering this case.
The records have been recordized.
Records received.
We'll hear the matter. Why does interim business? We'll hear the matter. Give me a date, we'll hear the matter. POSCO, there is something, so we'll hear
So
the
your
matter.
lordship will kindly see only one aspect, your lordship. I will just first point out. The Learned, your lordship, trial court, your lordship. First of all, your lordship, since IA is for a bail, your lordship, therefore, your lordship, only my case is that, your lordship, there are your lordship, witnesses are there, your lordship, 3 defense that has not been considered in.
What is the age of the girl?
Age, your lordship, 9 years, your lordship.
40. Item number.
68.
Girl,
9 years.
9 years. Date of incident?
It was, your lordship, taken, lordship,
the question document was sent to Chandigarh
Yes.
or to FSL?
Yes, both, my lord.
Why? Why
because-
both?
First, my lord, it was sent for, because there is my discrepancy in the memo number of the.
No, I got it.
FSL.
Why two organizations were given that?
Because first, my lord, it was, my lord, because since they are not satisfied with the order of the, my lord, here, my lord, that is why it is Chandigarh for central laboratory for, my lord. It is
What happened to that?
that report is awaiting, my lord, that we have sent, my lord.
That has not come.
That has not come, my lord, because.
And what report you have
This is,
got?
my lord, once after that, my lord, after getting the order that has been challenged, my lord, because for a clarification, it was sent FSL Kahalipara, my lord.
Why this repeated thing done?
This there, my lord, because
You
there
have
is
sent to Chandigarh. Wait
Yes.
for that.
Yes.
Why again you have sent here?
because as per the, my lord, report that's received.
What is, who are you?
We are in fact, my
You are teachers or you are?
we are the teachers, my lord, were appointed in 1999 when this was provincialized. Subsequently, school was yet to be provincialized. That was the case. The school
Basing
was-
on the writ petition, this was.
Yes, my-
that was a different, yes, writ petition.
That's a writ petition that was, my lord, allowed directing them to pay salaries. Against that, my lord, there was a, my lord,
Contempt petition.
oh, my lord, contempt is still pending.
Uh.
Then, my lord, the review was there, then the writ appeal was there, then SLP was there by the state. All those have been dismissed. Nothing survives now, my lord, by starting a, my lord, reinvestigation.
Is this that one of those matters wherein that I had the
Yes, my lord.
occasion to pass orders?
For one of payment of salary.
Salaries, the director and the secretary had come down. So thereafter, this criminal case or this criminal case
The
is
criminal case was earlier, my lord. My
17.
lord, final report was given. Then, my lord, there was an application for, my lord,
objection.
retrial, my lord, reinvestigation. 5 years, my lord. Then, my lord, that was allowed. Against that, my lord, quashing petition is pending. Now, my lord, these petitioners have received notice from the court, trial court, and they have appeared. And, my lord, there, my lord, in spite of two reports already being there in respect of a document, which is DEO says that signed, it was sent to, my lord, FSL twice. On the both occasions, it was stated that, my lord, it has been signed by the then DEO. Then, my lord, on an off date, an application is moved, and, my lord, his signature has been, that document has been for sending to, my lord, Chandigarh. So, my lord, our submission before lordship, my lord, when we moved that, the trial court was misled on an off date without hearing us, and order was passed. And that
What
was
is
not-
this report you have now? Whether that is in their favor or in favor of against them?
Because it reflects, my lord, is in their favor, my lord. Because
Third
they are-
report is also in their favor.
yes,
No,
because
third report is yet to come. No.
FSL, our
because
FSL. Just show me that report.
because it's a clarification of the memo.
Because my prayer was that, my lord, whether that document can be used in the trial or not. That is what I questioned, and the order I challenged, my lord, by they were allowed to take the document. When it was submitted,
Received on so and so 17 under memo procedural. The exhibit marking and opinion have been retained verbatim in the opinion number so and so. This consistency in codification mandate for chain of custody eliminates. So they have reiterated the earlier position
Yes,
in their favor.
in their favor.
there are 3 reports, my lord, in our favor.
2 reports and a clarification.
Clarification.
Okay.
So you may keep it
No,
in the
no,
record, man.
What I pray for today is, my lord, we are going to the, my lord.
You get that instruction what you have done
Lord.
with the Chandigarh one, right? When?
Because, my lord, in the event that report, what transfer
Again, come.
it is the same, my lord, then this petition
May not be.
Proceed. Need not be proceed.
But,
Proceed.
my lord, if it goes against us, then.
Then we'll have to examine whether the order could have been passed.
Yes.
Mr. MP Goswami, learned counsel for the petitioner, for the learned additional public prosecutor submits that he be granted further 2 weeks' time to receive instructions as to whether the FSL report from
Chandigarh.
from the institute at Chandigarh to which the question document has been sent in pursuance to the order dated 13/6/2025 passed by the learned CJM Morigaon in PRC number 885/2024 has been received by the authorities. He undertakes that in the event the said report has been received, a copy thereof shall be placed before this court. Sent to CFSL Chandigarh.
Copy, my lord, the original here, my lord. That was the order passed. The last.
Furnish the FSL report before this court.
The report.
FSL report.
Report.
So
Report only.
report must be in the original, my lord. Otherwise, they will be using it in the matter of trial. Because I am
No,
not
no,
praying
that-
for a stay of the trial, my lord.
No, that cannot be, my lord.
Oh, let it come,
There-
mister. We'll see what can be done. We are here. We are not powerless. We can pass orders.
Yes, but then if your lordship says copy
He
is the
done a
same,
copy now, like the report, FSL report be placed before this court.
Document sent for FSL signed by me. I didn't sign the document.
I remember. There was a case here. Contempt was there. I
we are
remember.
trying to make out a, my lord, case of forgery and use it in it. We have never relied on that document, my lord. Now they are trying to bring up a new
Now
case,
that
my lord.
connection is gone, but I found something more, but it was a contempt jurisdiction I was exercising powers. So it was very limited. There was a report also wherein you submitted in your name, it was that acceptance of the FR was made. In your name, the officer, your Gogoi. Who are you? The respond number 2?
Abdul Razak.
Abdul
Razak.
Razak, no?
I'm Abdul Razak.
So the DO, he submitted a FR was submitted, he submitted and no objection. Okay, fine. Then there was an application for, then inquiry was made, it was found that this is not his application. That is the case.
It is not a fact, Lordship. It was submitted and I filed one application, petition. And my-
Okay, then it's the other way around.
And I was out of
Okay,
place here.
okay, I forgot maybe. Okay. Let us see what happens
After 2 weeks, man.
after 2 weeks. Register to list this matter after 2 weeks. Three weeks ko idea. 15-10 ko idea. You have enough time.
Lordship. But, my lord, regarding, my lord, the report, my lord, your lordship has directed the report only, my lord.
Only report, FSL report, Chandigarh, if you get it, place it.
Chief, in this case, from last occasion, the 81 date before the here in this case, my lordship, it has to decide with regard to the section 20. Generally, what happens, my or if the statement is given, and in PW as deposition when statement is given, if it contraries 164, 29 bar is taken and it is recorded and conviction is confirmed. Here in this case, it is opposite. In 164, she has not stated anything.
What is the age of the girl?
16,
At the time of the offense?
16, my lordship. 164 years, my lordship, at the time of recording statement, one.
No. At the
Yes.
time of the incident also same.
Immediately.
Immediately,
Yes.
okay.
So she has not stated anything. As PW1, she has stated completely everything. She was brought on record the 164 and was cross-examined. At that point of time, whether you have given the 164 with regard to any family pressure. Stated clearly, no, I have given 164 on my complete independent. With regard to that.
You say that she is not consistent in 164 and in the deposition.
So
Okay.
in that case, much.
Yes, Mr. Das. Okay. When do you want this matter? The records have come. Records have come. We'll hear the matter.
My lordship.
When? Immediately on reopening.
On reopening, my lordship.
14.
not on foot. My lordship, can it be, if on immediately on reopen, then my lordship on 16?
16. Any problem, Mr. Das? When? 22? Appeal likha. It is seen that the trial court records have been received and the respondent number 2 is also represented by a legal aid counsel appointed in the matter. First, in the above view of the matter, the learned counsel for the parties have submitted that the matter appeal be taken up for consideration at the earliest. Also, as agreed to by the learned counsel for the parties, registry to list this appeal on 22/10, 23/10/2025
Obliged, my
for
lordship.
admissions.
My lordship, for
The,
get on appeal.
it's admitted.
It's a statutory appeal.
No, the appeal is admitted for
Yeah.
hearing. For hearing. For hearing.
It's a statutory.
I had to, along with the pending interlocutory applications.
Obliged, my lordship.
Deputy Commissioner was directed to obtain instruction.
The instruction, but Lordship, says it was the MPM fund was for construction of road.
No, that. Give a copy to Mr. Purkhaisto.
Lordship.
Both Mr. Purkhaisto and Mr.
Lordship.
Mr. S.S. Roy, in terms of the order passed by the direction passed by this court on 14/8/20, wide order dated 14/8/2025 in the present proceedings, has placed on record the instructions received, written instructions received by him from the District Commissioner, Kamrup, bracketed Metro, Guwahati. So before considering the same, this court requires that a copy thereof be furnished to the learned counsel for the petitioner as well as the learned counsel representing the respondent number 10 to 15. So, registry to list this matter again on 24/9/2025. A copy of the instruction furnished by Mr. is kept on record and marked as X for identification. Give a copy today, sir. Yes, Ms. Sharma.
Appeal, lordship. Hearing
How come there is a paper book here?
compilation.
Oh, yeah, but somebody, but the council has made it.
So I am appearing as an amicus. Registry made it.
Registry made it. But why is it not made in other cases?
In all jail appeal, they made,
They make. But I found jail appeals here, it's not there.
but they have to. May not be.
Yes, service complete.
It's 376, not necessary.
Not necessary. So it is ready.
Ready. 10 years imprisonment, already almost 5 years had gone after judgment.
Appeal admitted. So why is it for orders today?
Hey, yeah.
Oh, hearing.
76 2L.
Give me 2 minutes. Victim girl is witness number?
He is a defendant. An interpreter has been appointed, and C
Okay, PW6.
is PW6 and interpreter is PW7.
So basically your defense is character assassination of the lady. Yes. Only eyewitness, lady, girl, no, nobody else. How have you dislodged her statements?
Lordship,
PW?
PW6
6.
and PW7 is the interpreter.
Hmm.
Here my defense, that only defense, because the three he had appellant had taken the
Come to the cross.
PW6.
Hmm. So here she has described the incidents.
Basically, a child was born also.
Okay, fine. I generally go to the same area. No one was present when the accused committed so and so. There is no house near so and so. Fact that I had stated today false. Fact that I deposed fully when I attempted to go, my mother slapped me. After I did it is not a fact that. Guesses about me. So her statement, how have you dislodged?
DNA test was done.
That you have not demanded also.
Yes. Secondly, Lordship, the interpreter, the IO has stated that interpreter in somewhere she has stated that was and lagil and ullekh kora jen lagil regarding the involvement of the accused. So that much is the contradiction. Otherwise, it is a corroboration, Lordship, because in such types of cases there cannot be any.
The other witnesses say even in the mail that was
Yes.
held, she had
They have
clearly
pointed
said.
towards the person.
Kya rahi hai? What is that? That's
That's the
Heard
point.
Mr. B. Sharma, Learning Counsel for the petitioner. There is nothing here. Registry, heard Ms. B. Sharma, Learning Counsel for the petitioner at length. The submissions of Mr. R.J. Barua remains inconclusive. The registry to list this matter on 16/10/2025 for further consideration. It's gone. Hands are full. That's why no orders are being passed. I was looking into your 313 because the foundational facts can be held to be, what is your denial? Your denial is, your clarification is she is a characterless girl. In that case. This one. Now we'll hear you. Now I just wanted to look into whether there is an urgency that we should immediately look into this matter. This is item number? We'll have it after. As agreed to by the Learning Council for the parties. Give me a date.
After Diwali, my lord.
Any date?
On 28th, my lord.
28. As agreed to by the Learning Council for the parties, registry to list this matter again on 28/10/2025.
75.
ইয়াত কিবা এটা কৈছিলো নহয়, কি আছিল? There are 12 and 13 matters pending. 12 and 13 matters pending. Nobody is doing. Eh, 75 কিবা এটা নোট কৰিব দিছিলো নহয় তোমাক মই কিবা এটা কৈছিল No, something was said in the morning. I made a sort of make a note. I forgot. What? It is hearing organization. Admit. Raised it to list this matter for hearing in the last week of September 2025. That will not be possible today. 1 to after vacation. 1 to 30. 1 to 30 at our order. Due to paucity of time, the order could not be delivered today. But date did bond officer. I shot similar order tomorrow. 31, 32, 33. Hobo? Jikini Thagikul Mugdikils.